Lord.
One,
I have to go through the file
Which
of
list?
this of your lordship's court. Item 1.3. I have to go through the file, so I will be permitted to.
But then I think it is struck off. Item 13 of today's list is struck off. Right. Item number 10 to 27 are deferred. Yeah. 10 to 27 are ऊपर ही नहीं
21 क्यों मारी सर?
already deferred.
My
Item 13. Yes. 9 of today's list. Court number 7. It is a motion matter. The request of the learned counsel for the petitioner. June.
May I please, your lordship, with the consent of the other side, I beg to mention item number 24, pertaining to bench of court number 7. Your lordship, Mr. Pathak is out of station, so it may be adjourned.
Item number 24.
4.
APDCA.
Yes, APD.
You want it when?
I'm for the APDCA. I'm appearing on behalf of KP Pathak. He is out of station, so it may be.
When do you want it next?
Any day to.
At the request of the learned counsel preparing for the respondent party and not being objected to by the learned counsel for the petitioner, list this matter again on next week of the day. 4th of June. There is an interim order. The interim order passed earlier shall continue. All right.
Much better.
Thank you, sir.
The times of the item 28 and 29.
28 and 29 of which list, sir? This bench. You had brought it by order and you are seeking an adjournment. Why? This is for court number 23, item number 28 and 29. At the request of the learned counsel for the petitioner. List this matter again. Next week at a deputy. No, we are not fixing any date. Matter can attend for today. The matter was brought on list by order. And the mention has been made for an adjournment. You make a mention again, then it will come on. Up. Yes.
They're paying for initial construction. If I understand this.
Which list?
The construction after this will be.
Yes, what do you want?
Because
For the petition. But you are seeking item number 13. 12 is fixed with 13. Both of them. Again, when? Second of two.
On the last bench of
Yes,
Yes, sir.
okay, by beg to mention for listing pending cases in 21. In and
May it please, your lordship? Lordship, I'm audible?
Yes.
Lordship, with the due consent of the other side, I beg to mention item number 3, your lordship. Lordship,
Of
in this matter,
which?
we'll be filing our affidavit in opposition, my lord,
Of
during the
which?
course of the day.
There
Lordship?
are two lists. Which list?
Of the, my lord, of the, this court's list, my lord. Item number 3. My lord, he's already there, my lord. Of the
COT.
petition.
Anand Kumar COT.
Can it be on the 9th of next month?
He is proposing 9th of June, Mr. Fukon.
My lord.
At the request of the learned counsel, it paying for the respondents and with the consent of the learned counsel for the petitioner, and this matter again on the 9th of June. Okay.
Deeply obliged, bro. Deeply obliged.
My lord, in this case, my lord, it is pertaining to GIS of payment of the petitioner, my lord. We have been informed, my lord, some of the divisions GIS statement for certain periods have been missing, my lord. I have received the detailed instruction also. I was, my lord, seeking some information from the petitioner side regarding those missing statements. If we get those missing statements, my lord, we will process the GIS.
Mr. R. I. Bothatu, the standing counsel for the Forest Department, has submitted that a few of the statements of a few GIS statements relating to the petitioner are not
Missing.
available with the department. Full stop. Although the department is trying to fix the same, cooperation from the petitioner would help to expedite the matter. Full stop. He therefore prays for the listing of this matter after 2 weeks, in by which time the GIS statements would be tried to be traced out. The respondents would get liberty to ask for the cooperation of the petitioner to trace out the missing GIS reports.
Obliged.
At the copyright, none appears for the petitioner. Interstate transfer.
For a modest lots, there's no such policy lots, interstate transfer. What interpreting years are like the applications report are contractual or for consideration. Last location for public showed the whole of the better get what the content others with some terms and conditions signed by But we are fine for it because it's just the those of terms and particular was signed by single and other was provided.
Where is the appointment letter?
One letter of second is nine.
And where is your terms and conditions? Terms of contract? Terms of contract, where is it?
Terms of
Those of terms of contract was signed for the title was provided.
as he joined, my lord, I have written. Here. He joined in his, he reported joining by my lord, but he did not join in his place, my lord. And he was unauthorized absent, my lord. I have given my instruction, my lord.
And why a transfer?
I have
A person who
request.
joins, a person who joins.
No, my lord, we have, the respondent party has not transferred him. He requests for that.
You are asking for an interstate transfer. Where
Where
is the application? No, application when you pick the job. Advertisement. If your post was for the state of Assam, your appointment is by the mission director of Assam. Can you be posted out of Assam?
No. But these are the things, they proceed because on the medical ground.
For medical ground, you have other laws to help you. What is the medical ground?
Medical ground also I have an extra fee.
Mhm.
It was diagnosed not cheap, but regression with clear response.
So, how do you work in Rajasthan and not in Assam?
Actually, at least, there's not cheap, they not cheap to consider my application with the whether.
How can someone from the state who is responsible for the state of Assam transfer you to Delhi? Rajasthan, Gujarat. They do not know the position there, can they?
Okay.
It has to be done by someone centrally. Is he a party? The person who can do it centrally, is he a party here?
No, no.
Then, do you have the scheme in Rajasthan?
No, no, that is not what
Do you have the scheme in Rajasthan? No.
in the India, not in the party, but
Who appears for Union of India? Union of India has told the action. Madam Borwa, do you appear for the Union of India? Uh, this is a matter where the person is working under the NHM, National Health Mission. He was appointed in the state of Assam, suffering from certain illness, requesting a transfer to homestay. He was appointed by the director Assam. So unless a central agency is involved, no one can dispose his representation or look into his case. Is it?
Yes, sir.
So the page 2, respondent number 1 is the Ministry of Health and Family Welfare Authority. I can dispose it of saying that the NHM director should look into the representation and pass necessary order. One simple line, I am not authorized to transfer out of state. Finish. Is it not? Will not work. Can you have your instruction?
Yes, sir.
I don't know what
After
you want.
Required.
We'll have it after some time. Find out if it is allotted to anyone.
Right.
No? Otherwise, you have your. Otherwise, we'll ask you to. Should we ask you to have instructions now?
I said try, not check, but
Kindly ask. Yes, madam. Kindly ask Mr. RTD Chaudhary if he's available.
yes, that would be. I will inform you.
Either inform him or have Mr.
Yes.
RTD Chaudhary here,
Yes, sir.
if he can. After something. Huh? Yes, sir.
Lordship, as per last order, I have to take instruction, but we taken after some time, talk to the office, they're looking into the matter.
After something. এখন আধার কিছু রকম রাখে আগে কিছু Yes, sir.
Fortunately, in this case, we have to keep the thing that we take the next thing. We do your lordship, the charge room, your lordship will find that page 119. The amount of the charge,
Page
page 119, charge
119.
right? And the article of charges, they are page 121. Your lordship basically against your lordship article 1, 2, and 3 relates to non-submission of annual immovable property return. That your lordship will have already submitted number 1. And then your lordship will kindly next is article 2. Article 4 is regarding your lordship purchase of property by me. And 5, your lordship find that land records in access to be grossly failed and neglected to maintain accurate, complete and up-to-date land records of the receiver. Instead of discharging the consent, it deliberately conveys lenders to an external authority bypassing the prescribed official authority. Then Article 6 is relating to a complaint filed by me before the central government. And this relates to your lordship functioning of one deputy director, your lordship, whose appointment itself is selected by me, your lordship. And also relating to certain staff pattern in the office, your lordship, in statement. And Article 7 is relating to an evidence I have come here to give your lordship in a proceeding, your lordship. in the Bar Council of India, which is going on against my your lordship learned friend. Whether he can appear in few of that, I don't know. But that has been going on. And your lordship, in all these cases, your lordship, I have documents.
But Mr. Whatever, there's a difficulty.
My lord, I have not received the copy of this petition. I have taken the second copy of it.
We have furnished it to your lordship.
Moment.
In this case, we are not, we cannot take up the matter, Lordship, because in this case, Lordship, LGB Regional Institute of Mental Health, separate councils are there, learned and district council.
You have sent it by post. You have sent it by post.
No, your lordship, we have furnished it to CPS.
And for.
Says
This is the
For
central
mental
government,
health,
functioning under central government, but they have not told me that they cannot take. Not told me, my,
I have.
Earlier,
informed-
I contacted Mr. Thakur.
Yes.
Mr. Gauhati,
I have already informed.
inform him. Please furnish me a copy.
But here, the role of the institute is the LTDA. What is the last charge?
that charge relating to your 123, that is 8 3 by remaining members of headquarters. This was to unauthorized safety station headquartered on the 12,025 without obtaining fire from or be from competent authority. By leaving this. And in fact, your lordship,
Now, when he has to defend it, if he says the
My
authority
lord,
is free,
my lord,
we'll take it up on Wednesday. Fix it on your Wednesday, give
Wednesday,
him
your
the copy.
lordship is a competent.
And also, today is the first day.
Wednesday.
Wednesday will have it. The, Mr. A.K. Dr. and Council appearing for the LGPI.
this is not his issue, my lord, agreeing for the respondent author.
What this one?
Institute. SOP is there, by
LGPI
name I
which-
can.
Huh?
SOP is there, my lord, by name.
SOP
in-
is there?
My lord, there is a there is an order that the officials who is pass an order in official capacity, the standing on council may be appeared for them.
Hmm.
So by name, I can.
Even for the respondent number 6 and 7, you can appear.
Yeah. 2 to 7, my lord.
But Mr. S. Portable, learned senior counsel, assisted by Mr. D. Google, learned counsel appearing for the petition. You are anybody for Union of India?
Mr.
He is also for it, you know.
Yeah, but I have not received the copy of the entrusted to me. Well, perhaps I can.
Mr. A.K. Dr. learned counsel submits that he has instructions to appear for the respondent number 2 to 7. Stop. He however submits that extra that
No problem.
copies for the respondent number 2 to 3 had not been served prior to filing of the report. Mr. Gogoi, learned counsel assisting appearing for the petitioner has submitted that extra copies to be furnished during the course of the day itself. Is the matter again on Wednesday.
Take your. In fact. Take your. It's not super rushy, participating in the frictional process. They have completed all stages of recruitment. But in the final result, the result has been detailed due to the significant requirements data. Result was declared on matter 15/1/56 matter. So now not something has been done in the. Notice में गए हुए
Yes, Lordship. Lordship, in this case, Lordship, instruction not yet received. Can you notice? 3 weeks of time. 3 weeks of time, Lordship, we get obtain instruction.
But Mr. HR Ahmed Learned Counsel appearing for the petitioner. Your name?
R. Dev appearing on behalf of SS Roy.
It's RKT. Counsel appears from its Executive Commander CTC. Next. Who had issued an advertisement for recruitment of Constable General duties in the Central Armed Police Forces and SSF, rifleman in Assam Rifles and Sipahi in NCP for the year 2025. We learn a counsel for the petition submitted the results of the selection process have been declared in the month of January 2026 or 2025. When? 2026. However, the results of the petitioner's hearing have been kept withheld on the ground that there was some mismatch in their biometrics. Issue notice within 3 weeks, extra copies within a period of 4 days. List again on all respondents you represent?
Yes.
Since all the respondents are represented, no formal steps are called for. Extra copies within a period of so many days. List again on data review. 3. Opening of video, 14, 15th of July. 15th of July. Yeah. 6.
Casual employee. Working under forest department. And the very profit for minimum of pay scale. Under similar circumstances, these are all the first and the disabled state are in my cases also is going to be covered by the government.
Casual workers are covered. Casual workers are covered.
Case 77 was to be covered. It's going to be covered exactly similar. Without changing in any word.
Are you working against the sanction coach?
Yes, working. We are working.
We'll dispose it of to consider whether your case is covered by the aforesaid judgment.
Yes, covered by the
Whether it is covered or not, then we'll have to. They will make a verification.
Lordship may be disposed of, but with a direction after verification of the documents.
Regarding verification was to be a case 81.
80?
81. Last para 8. The verification is already there. They will do it.
Same order would do, madam?
Yes, Lord.
Page 80. There's an order. Any is to be made? Any changes? No.
Absolutely. There is no any change of water.
Dispose of.
Left.
Just a minute. Item 7, item 6. Item 6, petitioner is M. Khan. Item 6, petitioner name is M. Khan. What do you say?
Item 7, I am the petitioner.
Ah,
I have not mentioned this.
this is of the code number 7.
Code number 7, ma'am. Item number 7. WPC 2686 of 2026. I have not mentioned it. Maybe. Two 2686 of 2026.
No. Not mentioned. First, I think that's not the mention it.
I have not mentioned it.
You have not taken any of that. We'll have it day after tomorrow. Any urgency? Day after tomorrow. Day after tomorrow. Item 7. Day after tomorrow. Okay. Yes, sir.
In second round of litigation,
Hmm.
earlier round of litigation is listed as item number 62. But after you notice, the petitioner area advertisement was issued on 6/12/21 for filling some posts of constable and then unannounced. The petitioner hearing applied to the post and she succeeded in physical tests and all secured post marks, but she was not called for the interview.
Hmm.
Having noticed some anomalies, she noticed that 8 of the persons of the provisional list were already selected in the previous selection of the year 2008. So she filed a representation and having no answer from the representation, she filed a petition, which is item number 64 of the subpoena.
Hmm.
So during the pendency of that petition, the government has filed an affidavit. Therefrom, we found some more anomalies regarding the selection process.
Hmm.
But I'm keeping the advertisement and taking your lordship straight away at 8:54. That is the provisional selected
Page number 54.
54. This is regarding proceedings.
Hmm.
This is the provisional selected for the oral violation for the case.
Hmm.
From 2008, serial number 4008
Hmm.
till serial number 4034. These
Hmm.
are all women candidates. 27 number women candidates
Hmm.
of the presidency. Now, I have noticed that serial number 4010, 4011,
Hmm.
4013, 4016, 4020, 4025, 4078. These persons
40, 25 and
4028.
ah.
These persons were already selected in the previous selection.
Okay.
Now, I filed a representation the next day that there was no response, and they filed a certificate in opposition 860.
Hmm.
And I will take your lot to page 650 last line. Similarly,
Hmm.
Similarly, the list of selected female candidates unreserved of UP district along with their marks for both constable duty and constable duty has been provided by the Secretary Seva who is secretary 11/12/2023 and they are for constable duty. Srimati Rajashri Day, Srimati Jyoti Day, Srimati Kiran Ravi Das, and for constable Akitara Begum, and Srimati Sabina Yes. In this country, however, it is pertinent to mention that total marks of the two candidates who got protection for appointment against constable duty today, the unreserved category for 226 is less than the total marks of the petitioner, as the two candidates were called for oral viva voce against the EWS category. And later on, they got selection against unreserved category. They were called for EWS category and they were got selection in unreserved category. Now, moreover, all the 5 selected candidates have been appointed as well as this also includes Timothy 60 Day, hearing roll number 12, who had been selected in the recruitment process of an earlier advertisement and had been undergoing training as constable AD, but she has been chosen to take up appointment under the present recruitment process, arriving out of advertisement dated 6/12/2021 as constable UP. So they have admitted that some of the candidates who are not in the selection process, who are from the earlier selection process, they have been appointed. Selected in this selection process, which was for 2021.
Just 1 minute. You got the page 54 you are showing. No, it is here.
Yes,
It is here 4010.
we have alleged that he
Did not appear in the second test. There are two recruitment processes.
Yes.
Or one. Two. She was selected in the first recruitment process as an armed branch constable. She joined.
Undergoing
She
training.
joined.
Yes.
In the meantime, the unarmed branch constable second recruitment process came up where you had participated. She had participated in that also. She gets the job as an unarmed, offer as an unarmed now. She comes and join. What is the difficulty?
I can understand that it's possible.
Hmm.
But your lordship says the final technique, which they have given along with their PDFs.
Manoj Kumar, serial number 7.
Page 77.
Yes, once she is taken into the EWS category, then how does she get selected in the unreserved category? She appeared as an EWS candidate. She was called for by her. And then she again goes back to the unreserved category. Is that allowed? That is, as the two candidates were called for oral viva against EWS, and they got selected in the unreserved category. How do you do that? Because they did not have enough marks, they were called under the EWS category, is it not? And then they scored so well in the interview that they again went back to the unreserved merit. Your language is either not clear or I am not clear. Eh? Page 64, first paragraph, last 3 lines. Two candidates were called for viva against EWS first, and they got selected in the unreserved category.
Yes.
How is that possible? Once on merit, you go into the EWS category, then you come back to the unreserved category again.
No,
Can you?
no. It has to be considered in that compartment.
If some person who's appearing as say an EWS category candidate, there are 5 pages. Written phase, very well
Course.
done, unreserved. Then you have the physical test, unreserved, because she scored very well. And combination of the two, she does not make it to the vital. So you consider her under the EWS category. She comes into the EWS category, she is scoring enough to be called for the vital. You call her for the vital. Then, while publishing the final select list, you say no, we'll go back to the unreserved. How? Already she's down in merit. Viva cannot contain more than 50% mark. How will she cross the other unreserved category candidate?
Yes.
How can she?
Yes. Has to more than 60% of the
She has scored 36 in the previous round. She cannot score more than 49 here. Yes.
Yes.
How can she overcome the person who had
Other
already secured
unreserved.
49 in the other test?
No.
Can she? No, she'll never be able to. The
No.
total doesn't add up.
No.
Mathematics is we are
No,
understanding.
that we understand.
Item 64. Is it ready? Item 64, is it ready? What is the state in there?
Taking it complete of the last order.
But this challenge of the two different select procedures, I don't think that is going to stand. If she was selected as an armed branch constable in the earlier round,
And other things are also there. If the other persons who have already selected from the previous selection process, they have appeared.
if they have participated in both the selection process, there
That
is
is
nothing
not
wrong.
clear. That is not clear from the There are total 8 persons, and if they have already undergoing training and already selected in the previous selection list, that also the thing is the cut of. They have not answered it.
In this affidavit. That allegation was there in the petition that from the earlier selection, they have come to the second one.
But in the petition also,
Or should we take it up along with item number 64
yes, but
in the second half? Let us finish some of the motion matters. We take it up in the second half.
So I think we should find one affidavit in this point of
We'll
view.
try to find out if they made a statement in that petition saying that there were 2 different selection processes where the both of them are part. If not, instead of going round and round, we'll ask for a simple affidavit from you whether these candidates had participated separately, marks in each of the selection process will be placed before the court.
At two, Lordship.
No, we'll take it up in the second half after we finish some of the matters. We'll see what is put. None appears for the petition on court. Next, when the petition senior government advocate appears for the respondent number,
All the respondents, Lordship.
for all the respondents. The matter relates to the disciplinary proceeding against the petitioner on the ground of its being taken into custody. After the petitioner was arrested and the charge sheet was submitted against 4 accused persons, including the department. List the matter again on any people. 16th of June, no, 15th of June 2026. Means Bhagataji will be at liberty to have our instructions in the matter. We are not issuing notice in the matter.
Lordship, I
We
will
just have
have,
your instruction.
yes, Lordship.
Appears there was a charge sheet against him and he has been dismissed after a discipline proceeding
Lord.
when he was in jail.
Lordship, that I
Could be done.
deeply obliged.
Yes, sir.
In 2017, that those who have died before 2017, they may apply for completion. But in my case, what happened, my lord? I was not at all. This is why my father, not my maturity, he stipulated time of 3 years. That is fine. You know, at this system, it's not like.
He is not having a happy face even on notice. Yes.
My lord, the very first thing is that there is no such notification on OM, my lord, which says that prior to 2017,
Yes, notification.
they can apply. There is no specific such notification. Number two, my lord, a minor, my lord, cannot claim,
Would not have applied
my lord,
after he becomes a
becoming major, my lord. There are judgments of this honorable court, my lord, referring to Supreme Court's, my lord, order, my lord. 2 judgments have been passed. I have now, right now, I have one with me. I can place it before your lordship. And third is that, my lord, for compensation department within 1 year, my lord. 1 year is the timeline, my lord. Within 1 year, it is to be applied. If you go by OM also, and that OM has come, my lord, because of a judgment of this honorable court. Federal Nisa, my lord.
After the correction, my lord, it's not 1 year.
My lord, I can go by the OM and judgment also. My lord, I'm just placing that minor thing, my lord, that has been curtailed by this honorable court. Who said that it cannot. Upon site, yeah.
Yes, sir. Minor cannot apply after it becomes a major anything to after like.
But in that case also, but my humble submission to period also, they could clarify the position, at least things not officially.
And you repeat it.
My lord. But my lord will record my objection.
But which I may check when it comes to the thing for the petition. Instead, are the learned counsel appearing for the learned additional senior government advocate paying for the respondent. The learned counsel for the petitioner had submitted that the father of the petitioner had expired on 31/12/2014, and the petitioner, who was a minor at that point of time, would not apply under the scheme for appointment on compulsory basis, which was then prevalent. The council had submitted that the mother of the petitioner had applied, but being an illiterate, her case perhaps was not considered by the respondent. The council for the petitioner had submitted, for the petitioner had applied. Thereafter, when sir applied thereafter in the year 2022, however, in the year 2026, you write like this, on 18 to 2026, but the respondents have not acted upon the representation. The council has submitted that the petitioner's case results are considered. The additional senior government advocate has submitted that it is settled by the court by the order dated 12/12/2023, passed in WPC 6916 of 2023. And that the
Last placement. There is no doubt.
that, that there is no government circular in the state of Assam permitting a minor to submit related applications seeking appointment on compulsion drawn upon in third. The court had held that in that case where the delay was more than 16 years from the date of death of the deceased government employee, there was no ground for anything to be set with petition. The counsel for the petitioner had submitted that the respondent should have instructions in the representation filed by the petitioner on the representation on the date of the representation filed by the petitioner. This matter again on 12th of June 2026, and allowing time to the respondents to place for the spot the date of the representation filed by the petitioner for confession. Extra copies will be supplied to the petition petitioner for the vote. Yes. After some time. Will this case be affected by the recent development? Writer of land records. There may be some recent development. Kindly inform the council. 22. We'll allow it.
No, Lordship, she never joined. We have instruction.
No, this is an
Yes, Lordship.
Yes, we'll strike it out.
Yes,
We'll strike out the
Lordship.
The present application is being filed with a petition praying for deletion of the name of the respondent number 5, that is the accountant general, within bracket capital A and E, bracket close, from Assam, Madam Gaon, Beltola, from the array of parties in this petition, which the Learned Government Council preparing for the respondents that do not object to the same. So accordingly, the IS allowed the respondent number 5 is struck off from the array of parties in the present petition. I accordingly allow. Next, you writing the petition. Today, by an order passed in the interlocutory application number 1489 of 2036, the respondent number 5 has been directed to struck off. Accordingly, the petitioner shall file an amended cost title before the registry of this court within a period of 7 days from today. List the petition in legal court. BTC. Yes, madam, affidavit prepared not by.
Lordship, certain instruction we have received, it is also ready, but it is confusing, so I'm praying for some time to file.
Earlier occasion, you said it was sent for vetting and
Sent for
everything.
vetting, but Lordship, the documents were some confusion is there, Lordship, so I'm praying for some time.
No, it is for the petition and for the council applying for the PPC had submitted that although the later some more instructions were provided, which led some confusion in the matter. So accordingly, she seeks some more time to. You are appealing for?
On behalf of
It's your name, madam? To put it on a council applying for the respondent number. Who?
I'm appearing for referral report.
You are appealing for, you are appealing for respondent number 2. Animal husbandry and veterinary. The respondent number 1 and 2. You are not filing any affidavit?
No, madam.
That means that the state department could not say the respondent could not be filing any. Is the matter again on the 18th of June. 18th was the 19th of June 2026, allowing the respondent to file there. Okay. 6.
This case, my lord, to solemnity, selection and appropriate authorized with the affiliate products that are passed by the direct for the minimum. It's 25. The private respondent file the calculator, they also appear last time. And two times also file the regulation.
File.
Kindly tell us what is your ground?
My lord, my ground was basically three grounds. My lord. First of all, my lord, I am the son of the Gaura. Secondly, politically, there is the involved in politics, my lord, and the document is reveals and other part that is not considered. And we we enact the document regarding the involvement of political party, and which is the mandatory requirement, the advertisement. And they did, my lord, they paid the column number 9. The person who have involved in politics is not eligible for the outcome.
Yes, any affidavit proposed, sir?
No, sir, affidavit is ready. We have sent listing for swearing. So it has not been 1 week time.
Just here for and considering for the respondents, it's submitted that the affidavit is ready and it is filed within a very short period. Mr. Ali appears to the petitioner and submits that the matter relates to selection and appointment and has been pending since 2025 and paid for early pay. Basic matter again on the 19th of June 2026, by which time the respondents shall ensure filing of their affidavit.
They are not,
Have they been served?
yes, my lord, they appear.
None appears for the respondent number 5 from others related came yet today. They may also file, the respondent number 5 may also have the affidavit filed on or before the, what did I say, 19th of June? 19th of June to the. Item 27 was discussing before. Huh? No.
I was voted by application. That's a matter.
Yes, Mr. Potago.
My promoter has a camera file because my one basically family is me. So far, it means prime actually is concerned, he was given promotion. As
Same
per-
case, in the same
Yes.
case.
She is the prime accused.
Ma'am,
This is the order passed by this.
this is Mr. J.K. Goswami, a request in your comment. We have it after some time, let Mr. Goswami be here, he was appearing on all the earlier occasions. And that pendency of an investigation would not be enough to withhold a promotion. He was the judgment of it. We try to have it disposed of. J.K. Goswami had a school debate.
Right, next.
Hmm.
The petitioner was earlier was the employee of the state warehousing corporation, my lord.
State?
Warehousing corporation.
Ah,
Thereafter, they got retired, my lord. They filed a case before this honorable court for pensionary benefit, my lord. Some pensionary benefit will be granted, and some are yet to be gotten. For that, my this case has been, they are already established again. They want to take file.
you are appearing for respondent.
Yes.
You are appearing for the,
appeal.
then why are you
Oh,
standing on the other
Sorry,
side?
my.
We follow a certain procedure, we get confused.
No, he came this said so I.
Mr. Shekhar,
No, BD Chaudhary.
BD Chaudhary. Already some Mr. Shekhar had taken. back.
Yes, he has taken some time, but there are some instructions are still pending. Because there are some more employees like this, and some instructions are there, there are some.
Mr. Chaudhary, there are considering the respondent number 123.
Yes, sir.
Have paid for an accommodation to file the affidavit in opposition. The law counsel for the petitioner does not predict the fair made. Earlier occasions also time was sought to file affidavit. Is the matter again on the 19th of June. By which time the respondents will ensure filing of the response to the. Matter relates to grant of pensionary benefits. Not a person.
I'm going to have a private respondent or respondent of court.
Yes, then.
Lordship, we have received instruction, in this case is regarding Gauhura's appointment, which was as per BTC authority, Lordship. This has been without any authority they have appointed, and press recruitment proceeding is they are taking to Lordship.
Even respondent number 5 is out.
Lordship, this is
Let's go.
the instruction I have received.
But I have to- Yes, sir. Your in charge goes.
Let them file the affidavit.
Eh?
Let them file the affidavit.
None appears for the petitioner on call for criminal counsel. None appears for the petitioner on call criminal counsel appearing for the PPT has submitted that the appointment of the respondent number 4 had been done without any selection process or approval from the PPT authorities, and hence the appointment is not valid in law. It is also submitted that the BTC authorities will be initiate the recruitment process with the number of within the area very soon. Accordingly, she placed for some time to find her response to the petition. The council applying to the respondent number 4 has submitted that he does not even the issue. This the matter again on the 19th of 22nd of June 2026. Allowing the PTC authority to file their if it in the matter. So the authorities would be able would be this petition could not be a bar for the authorities to take appropriate action in accordance with law with regard to the earlier appointment of the respondent number 22nd of June. Health. Why don't you pay for
Already, Lordship, we have paid, Lordship.
Saying that there is some loan,
Who is the bank? Who is the bank?
SBI,
Who appears for the bank?
They are not made a
Is
party.
the bank a party? You have the bank name.
SBI, Gitana.
Unless they are a party, can we bring them here? For a person who is not before this court, can I give a direct? No. There are judgments of this court saying that unless you go through the BRT proceeding or some proceeding, money in your account cannot be touched by the bank. Make them a party, give me the judgment, I pass the order. Before they deduct it from your account and adjust it to their loan account, make them a party and take an order from this court, telling us that please pass an order for a party who's against a person who's not before the court. How can I do that? Cannot do that. Implement and disposal. Implement, interim order and disposal. That is here. This again, the Learned Council brings to the health department and submitted that the compassionate family pension along with arrears.
Yes, Lordship.
Along with arrears, etc. have already been deposited to the accounts of the petitioners. The accounts of the beneficiaries. Of
The guardian.
deceased employees.
The guardian of the petition.
Guardian of the petition. The Learned Council for the petitioner has said that although the money has been deposited in the account, the same has not been disbursed then by the concerned bank, which the concerned bank is not party. This matter again on. How soon? Pick the name of the bank. Who is not a party. You do it before for fifth of June, we'll have it before fifth of June. They have it on Friday. Yes. Okay. Let me, I can, 34. There's also can in the last order.
We are filing the affidavit today. In fact, I have given.
Relax. You will apprise the court why you are not allowing him to go.
Because the affidavit I have already given the
The order says you will apprise. Kindly apprise.
Lot. But after the promotion order was given, an information has come that there is a proceeding is pending against him. That is
What proceeding?
A case was pending.
Police case.
Yes.
Okay.
And-
Therefore, you are not allowing him to go.
Yes.
Then there I have been discussed from the police case. I am this far. Then I was.
All those we will hear once the affidavit comes. Their reason for not allowing you to join is the police case.
Yes.
That is what we will record in the order. We will take his affidavit on record. We will hear the matter on Thursday.
I am no question, but you lost of idea. There is no police case at all.
They may be correct or they may be wrong. Unless the affidavit is before us, can we consider? No. Let the affidavit. You are filing it when, sir? Okay. But Mr. Chairman, Council also heard Mr. D. Naklan, senior government advocate, appearing for the respondent before the next. In compliance with the early order passed by this court, the senior government advocate has submitted that the reasons for not allowing the petitioner to join in his promotional post has been incorporated in the affidavit. One of which is that there was a police case pending against
Pendency of a criminal case.
pendency of a criminal case. The learned counsel for the petitioner has submitted that there is no police case pending against the petitioner as of the time. However, these aspects can be considered only after the affidavit in opposition, which is supposed to be filed today itself, is brought on record. Accordingly, this the matter again on Thursday.
Thursday is a holiday for them.
Thursday is a holiday. We'll have it on Tuesday next.
Yes, sir.
On Tuesday next. Second of June 2026, along with the affidavit proposed to be filed by the respondents to the petitioner would be at liberty to file a reply before the next date fixed, if so advised. Ending. Ending, madam? Ending. You take them.
Participated in the recruitment process. OBC candidate, but they did not against any candidate. Yes, OBC candidate as granted to the advertisement. Accordingly, their name was recommended. They got the marks above the general category. Accordingly, their names are recommended for general category. Therefore, they have been appointed. After that, my lord, after appointment, their appointment has been sent, saying that, my lord, the petitioners belong to Vishnupuria community, and that community not state in the central district. But petitioners already not recommended, my lord, for general category.
The certificates is the genuineness of the certificate question.
No.
They are issued by the competent officer. They can have their investigation on the same. Whether they belong to a particular community or not is not an issue.
Not a.
Vishnupriya Manipuri is not
Oh,
come.
forget that, madam. Tomorrow I will say that I am the president of India and I'll give you a piece of paper saying that I have been appointed by the UN, that I am the president of India, okay? That paper is not taken into consideration, number one. Number two, the letter which I show you is not a fake or forged letter. It has been issued by the competent authority. What is my problem?
Vishnupriya Manipuri is not come.
Vikas Chandranath versus Union of India, go and read into it.
I have,
It's for admission. We'll take it up at 3.
the affidavit is sent for vetting.
We will take it up at 3. We'll give you time for your affidavit. Please find out Vikas Chandranath versus Union of India. This will not take much time. You don't know that case. No research. No research. Very soon. Very soon.
Kind-
From some people, we expect a little bit of research.
On next date,
We are not disposing it today. Just
Yes.
go through Vikas Chandranath. Come back at 3 o'clock.
There's many cases of covered failures, but they have not been.
When a Maruti car can do the job, why are you bringing a bulldozer? Get Vikas Chandranath. Yes, sir. Mr. Bodhagur.
that's kindly pass over the matter for timing lordship. Architect is relaxed.
This is for what?
If the case may not be transferred,
Transfer. Then let after for the Or should we take it up at 2?
as per your
So that there is no uncertainty to it. We'll take it up at 2. At 2, madam? Ek mati dibo. Ek mati dibo. Door to tell him. Yes, sir.
As per the last order, lordship, 4526, so I have not received the instructions, lordship. It's an old
See
matter,
the instruction.
instructions, lordship. So some time, further time is required, lordship. 2 weeks, lordship.
What is the case about?
What did I find?
For what?
I just find that 70 back something. FPS.
Into what?
Actually, he has to refund the bond money. He has to refund the bond money.
Did he touch his matter on some earlier occasion? Yeah.
He has not completed the 10 years. So he has to refund the money
So,
as per the,
why don't you refund it?
I don't, that's fun, but
No, why don't you refund it? Why don't you refund the money?
so I agree with that refund, but
Ah.
I have already 13 years I started from MBBA.
Uh,
So to PT,
for
it is
PG, you
different,
need to
lordship.
serve for another 10 years.
Yes.
So 13 years you forget, you have served only how many years?
but I have already 70 lakh, something, already deposited government. Has to do.
It is with you.
In NPS money.
That is NPS
So
money.
NPS of money, how
That
can
is
they withdraw?
different, lordship.
That can.
How can they withdraw? You withdraw it and you give it to them.
Give them on road. My
You-
money was just deducted, right?
You withdraw whatever money you want to withdraw from wherever you are.
Yes,
Give it to them, they'll do it.
this is
Just-
the
just-
bond money.
Give it to me, fine.
Nothing. You will take up a post, you will take up a seat. Then you will say that, no, I want a posting here, I want a posting there.
Happy. Just from
He'll come back at 12, you take your instructions whether he would withdraw and give it to them. Let him close his NPS system and give it.
if they adjust, I know.
Let-
That cannot be
let-
adjusted, lordship.
That is the whole problem. They cannot adjust. Okay. NPS is key.
Yes.
How can they adjust?
Our money. Let
With whom?
already our.
Where is it supposed to be? With the respondent, with the health department? No. With the national pension scheme of it. Not with them. How can they? They will not tell you.
And as per the bond lordship,
Huh?
When did I got it?
When did I go?
I took money.
Ah. You tell them, I want to close the scheme. They will allow you to close the scheme. You write a letter to them, they'll give you a check. They give you the money. And if they don't give you the money, arrange your money.
Then that money will automatically come.
Come back at,
My FPT, no, it's 70. Yeah.
before that lordship, he has already filed an affidavit of undertaking that he will pay the bond money before 19/12/24 in page 66 located. As per order dated 18/9/24.
I agree. I never. What to sir, doctor sir, will not file anything. I filed. Not to take.
I mean, not to, not file any case,
I
then what are you
think
thinking?
I also already agreed to keep them. But question is that it's huge money.
Then why did you undertake?
Huge honor.
Then why did you undertake?
And I think I will to keep it. I want to keep.
You undertook to give it before the 18/9/2024 or 19/12/2024. We close it. We close the writ petition, saying that you have not kept your undertaking.
So I have already 70%. I have clearly written.
There is no page 70.
Page 70, my affidavit.
17.
70.
You don't find any page 70.
Affidavit.
Meet affidavit, additional affidavit.
No.
Where have you undertaken? Tell us. Where is, read the sentence.
Right.
Read the sentence.
That I have submitted that since the year 2006 to 2018, I have completed the work.
Call for the,
13 years.
when did you file it?
11/5.
2000? You have the filing number? List this matter. Along with the affidavit stated to have been filed on 11/5/2026 by the petitioner. You pay, then you go, otherwise we are closing it on Wednesday. You are in? You are not holding somewhere? The government is suffering without your service. This is your right. 28, yes. Mr. Talukdar, R.K. Talukdar.
I am appearing for architecture. We have our instruction. PPO and GPO was already.
Some PPO was issued.
Yes.
But the provisional. Same inspection here. They were to annex the pension. But later file affidavit.
2021, is you are saying in the
Date,
PPO.
date, today's date, but it is, no, yes. And
It's not like this, wait. Which one is it?
Today's date is, yes, my lord, by pay, and 30/8/2021 is dated.
Ah. If senior accounts officer, when can he come? On Wednesday? Mr. Choliha? No, he's not there. You are for the AG.
Yes.
Ah, then 2021 letter, he says that it is provisional pension. Is it not? You are supposed to give him the final pension orders during his lifetime.
By refixing salary and allowance.
You did not do that. You have not given him final pension orders till today?
Lordship, we have communicated and this is the instruction currently.
Ah,
we
so
have received.
since your communication has not worked, Wednesday. Your name, madam?
B. Nandini, appearing on behalf of party counsel.
Before this court, right, produced before this court and letter issued by the senior officer. Issued on 3/8/2021. Taking the PO number 28. Yeah, correct. Then to the treasury officer for February. How do we know this is a provisional pension order?
This one, kindly, Lordship, kindly keep it number 45, you know, the pension, I mean, order, my lord. There is a pension kept in arrears. Here number 10 and 11. The detail, you know, repeatedly approved, but they not attend the monthly pension.
Pension kept in event, there is nothing.
Yes, ma'am.
Pension committed is nothing.
11, serial number 11, provisional pension is given. There is the date. But monthly pension is not yet finalized.
How do you know this is provisional pension?
Number 74, they are later, my lord, issued by the AC, town and officer of,
Huh?
on the page number 74. They are sought for some instruction from the, my lord, government department. 2007 for last week.
You were working in which department? Panchayat and Rural Development.
Outside department.
Yes, sir. What do you say on page 74? Your case is that you were given a provisional pension.
Provisional pension.
This was filed by the retired employee originally. This petition, who filed it?
But the petition regarding to.
The retired employee, saying that I want my final pension order.
Yes.
During the pendency of the proceeding, he expired. He did not get the final pension.
Not yet.
Now his heirs are here before the court, substituted. Your case is that your father never got a final pension order, and now, even now you don't have a final pension order, and therefore your family pension is not being fixed. That is your case?
Final monthly pension was not also fixed. Provisional was given. And my lord, now family pension come. Yes.
Is it being paid to you now?
Not now, that is recently stopped.
They have again stopped it.
Yes, my lord.
Why?
Due to my lord, the death certificate is submitted and the proceedings is going on for family pension.
So family pension has not started as of.
Not yet started, fine.
Okay.
I have.
Yes, sir. Page 74. Madam, let him take the time. Please come to page 74. This is a part of what?
This is
Part of the repetition, yes.
from the secretary to the AG regarding his
No.
fixation of
to the secretary from the AG.
Sorry, to the secretary from the AG.
Ah,
This was in regards to the EB crossing of the
for which
petitioner.
is, for which his pension could not be finalized.
Lordship, that I don't know, because
That
as per
please read the letter, you will know. That you do not know, are you appealing for the AG?
no, Lordship,
You are appealing for whom?
PNR,
PNRD. You are standing counsel of the PNRD. No, who's the standing counsel?
Mr. S. Datta.
Getting.
The special report was, inquiry was made, for everything.
After some time, let the standing counsel be.
By the state level committee. No appointment for the state level committee.
He is gone.
But the 23 already recommended by the state level.
Ah,
Page number 76.
yes, madam. Already recommended, why not appointed?
Applicant put, vacancies are not yet been listed.
Where do we find that?
Rashi, madam. Rashi,
That department. In your department?
Yes, madam.
Yes, madam. Ms. Bhattacharjee,
Rashi.
there is no 5% vacancy available in that department.
Yes, Lordship.
Already they stand recommended by the SLC.
Lordship.
So therefore, these two office memorandums of 18/9/2024
Lordship.
and SOP of 38/2025 are not applicable to the case of the petition. Therefore, now you have to call for the vacancy positions from others and consider the appointment if there is no vacancy anywhere.
Lordship, first of all, the date of death has to be considered, Lordship.
SLC have already.
But SLC provision is there if available. If available, if not available, Lordship, they will not be appointed.
The law as we understand it,
Lordship,
it is not in the same department.
Lordship,
Then the other departments have to be considered.
Lordship,
Vacancy position from other departments have to be called for. And if it is not done,
Lordship,
if there is no vacancy even in the other department,
Lordship.
yes, then there is no vacancy anywhere, sorry. You are a copy. You take it up on the
Wednesday, I am available, Lordship.
Thank you.
Yes, this question. Yes, here also, Lordship, these things happen. But considering the recent, all these things.
Lord, all for the other departments, they keep on spending. No vacancy then, right? If there is a vacancy.
Lordship, if if I correctly appraise Lordship, those whose cases were pending and those whose cases were recommended by the SLC Lordship, all these cases have been taken up as per the judgment passed by this Honorable Court in Abdul Kader Bukchi Lordship. So thereafter, all the departments has been, that means there was a meeting Lordship, and this has been now been given to the each and every department to dispose of the matter on merit Lordship. So this is the
Already taken a call.
Lordship.
What more remains to be disposed on merit? SLC says that yes, he can be considered,
Yes, Lordship.
and the law says that if it is not in the same department, the chief secretary has to take a call
Yes,
on that part,
Lordship.
whether anywhere else it is available.
Lordship.
Have your instructions on this? We'll fix it in
Lordship.
June. Third week of June. If it was not,
Monday, Wednesday may not be possible.
we'll have it on 22nd of June, no difficult.
Okay,
Have your instructions on this, whether
Lordship.
he has been considered in some other department and has been informed.
This, in respect of the petition.
Only petition.
Lordship. I shall.
Whether he can be accommodated somewhere because the SLC had already.
Lordship, Lord. I shall have.
The council agreeing for the petitioner has produced before the court an order dated 13/3/2026 parked in the PPC 3739 of 2023, whereby it was held that in cases where the state level committee had already recommended the appointment of the petitioners, the respondent authorities would be under an obligation to find out whether there were vacancies available in departments other than the department where the deceased government employee had served, and therefore take a call as to whether the petitioners could be accommodated under the scheme. Next, and what is the deed government advocate has sought for a accommodation to have her instructions regarding the consideration of the case of the petitioners. List again on the 22nd of June, allowing her to take the inquiry.
Lord. Okay.
As a case is that my lord, mother of the petitioner, he was appointed as the Mohammadabadi worker in the year 1910. Then he expired in the year 2020. Then my lord, the managing committee and the of the center, they took a decision for a resolution that the petitioner, who is the daughter of the queen, she was allowed to work as a Mohammadabadi worker in that center. And that was communicated to the office of the city. Then, in the meantime, the office want to fill up the post by way of promotion from the helper to Mohammadabadi worker. So they issued an advertisement. I have challenged that advertisement. Then, my lord, this honorable court state the person interim order that the post should not be filled up by way of promotion. Now, my lord, my contention is that, my lord, there are 4 centers in that revenue bidding. And out of 4, my lord, the 3 candidates, they are not eligible. Only the private respondent, she is, my lord, since she is claiming that she passed the class 10 examination, so she is eligible. So, my lord, in the meantime, my lord, after passing the interim order, the CTPO again, my lord, issued the, my lord, promotion order. Then I filed a contempt petition, then it was kept in abeyance. So, my lord, my instruction is that, my lord, the private respondent, she was reading in the class 9, my lord, but she did not pass the 9 examination. And as per criteria, my lord, 9 pass certificate is required. So, in this point, my lord, I sometimes take instruction at 9. So, I don't have any, my lord, opinions to that effect.
You are paying to the private respondent?
Yes, Lordship.
You have your certificate class 9.
Lordship, Lordship. That I have annexed, Lordship, in my affidavit in opposition, Lordship.
And I want to verify whether that certificate was issued by.
Lordship.
And my lord, there in the petition is that to issue an advertisement, general advertisement, so that I can also apply it. I'm not seeking for any appointment. So that I can also apply, participate in the.
Since the respondent number five.
Five.
I'm sorry, Lordship, that advertise, that application
not
for
been
that
annexed, right?
certificate, that has not been ended. I'm sorry to say, Lordship. But my appointment, my promotion, that has been in accordance with the guidelines, Lordship. I was
You are
working,
required to be class 9 pass.
Lordship,
Make
I
a
was working
statement
as helper, Lordship, since
Make a
2011.
Make a statement that you are a class 9. Make a statement.
Lordship, I may be allowed to produce the certificate then, Lordship. Lordship, that is there in my interlocutory application, Lordship.
Subsequent ballot in the affidavit, it is come.
Lordship, in my application for implement, Lordship, there I have annexed, Lordship. Lordship, page number 12 of my IA, Lordship. She was reading in class 10. This is the certificate of the headmaster.
You want to have instruction from
Certificate.
Page 14 also, Lordship. Page number 14 also, this is the Board of Secondary Education. The certificate is there. This board has a certified as Srimati Rose Sultana Ahmed. Is registered as a student of this
Case
board.
14, my lord, is registered with this board as a student
Of
of class
class
9.
9.
But my instruction that he did not pass the 9th examination final exam.
moment you would have passed, you would have got her registered in class 10. As a
Class
student of
9,
class 10
class 9 registration.
in the council.
This transfer certificate is
for accommodation. The registration is in class 9. Once you
Class
pass
nine.
class 9,
Lordship.
then you get a fresh certificate for class.
Lordship.
So the board also has to keep a track.
But this transfer certificate is there that she was reading in class 10. That means past class 9.
It's a matter again of the proof of.
And you can
Lordship.
my lord, that offline.
That's why the sector is functioning.
Yes, my lord.
He is the helper.
No, now by that honorable court's order, Lordship says that my promotion order has been kept in abeyance.
But you are the helper.
I am working in another center, Lordship, as helper. There is an office order to that effect, Lord.
Yes.
Yeah.
Lordship, the paper has been received at the office, Lordship. Certain time is reason the process, 2 weeks time, Lordship. This claiming family pension.
Yes,
We have received the paper, it is under process. So 2 weeks time. they took.
at the request of Mr. B. Chakraborty, learned pending conflict, accounting general. Please matter begin after 2 weeks. And again, on 24th of June, 2023. Allowing him to obtain his instructions in the.
Okay.
Lordship, can you hold up his phone? No, not taken. So what to do?
Lordship, in the earlier case
Your
also,
submission that you said necessary that you have the promotion given effective within a period of 15 days? Or our direction that you should do it within a period of. Choice is what?
direction.
No. When can the promotion be paid? Huh? What Mr. That what done at council appearing for the petition? Also, what Mr. Secretary done at council appearing for the response. Notice in this matter was issued on 1/8/2025. Although no affidavit in opposition has been filed, Mr. Goswami submits that the petition that he has given the instructions from the respondent authorities that the matter in which the matter in which the petitioner was alleged to be involved in has not yet culminated in a charge sheet. Yes?
Yes.
Has not yet culminated in a charge sheet and
Goes with case number.
and there is no disciplinary proceeding pending against the petitioner. Next. In light of the above, with the consent of the learned counsel appearing for the contesting parties, this petition is taken up for discussion. The petitioner, while posted in the SPF Assam as an sub-inspector within bracket Khana branch, was arrested in connection with corporate and accordingly, thereafter, disciplinary proceeding was initiated where by the order dated 6/5/2020, the petitioner was exonerated from the charges of serious misconduct and dereliction of duty. The petitioner thereafter passed departmental examination and pre-promotion course for promotion to the rank of sub-inspector within the Panam branch, and by the order dated 2021 passed by the the petitioner. You no promotion order in your. There was no promotion order.
On a page 79, you have page 61. The other matter, the SIUP has been the promotion. It is all total 542 matters.
Thereafter, by the order dated 7/2021 of passed by the Director General of Police from Assam, a total of 540 members of ASI duty were promoted to the rank of SI duty without considering the petitioner for his promotion. Similar case.
During pendency, he was promoted also.
Simanta Gogo. The learned counsel for the petitioner has submitted that the petitioner having been cleared of his charges in the department proceeding and there being no charge sheet pending against him in the competent court, in the competent criminal court, the non-consideration of its case for promotion by the respondent authorities requires an interference of this court and the respondents are liable to be directed to consider the case of the petitioner for promotion from the post of ASI within bracket UP to the rank of SI within bracket UP by applying the same yardstick which had been applied for the 542 numbers of ASI UPs promoted by the order dated 7/8/2021. With an account of and order dated 11th of December 2025. In respect of one of the co-accused in the same virtue PS case who had been considered later on and given the benefit of the promotion with effect from the year 2023. Was given promotion. Mr. Proposed submits that by in the effort, that the person involved in the order dated 11th of December 2025 had initially be granted the promotion, but the same was not given effective due to the involvement in the separation process by the order dated 11th December 2025. The promotion of the specific person has been given effective from 21/7/2023. Which the community directed to consider the petitioner on his own merits along with the other and by the same yardstick as has been applied for the other promotees and granting the benefit of promotion from the date on which the immediate junior had been granted the promotion. But there was a promotion. Yes, man. That was not the way effective, but we have not taken that we were given promotion from ASI to SI. Which is, we also was granted a promotion. We learned it council paying for the state respondent. Submitted that since there is no department, since there is no charge pending present with regard to PS case number 191 of 2017, and since he has already been exonerated in the departmental proceeding, the respondent would not be averse to consider his case for promotion on his turn, as had been given to his juniors by the order dated 7/8/2021. We have heard it. The court is in agreement with the proposition laid down by the court in the order dated 25/5/2023 passed in WPC 448/2023 where it was held as follows. No, where it was held that even is found to be involved with proceeding or in a police case which had been charged, his case had to be considered on its own merits and it kept in a free cover if necessary. Stop. The further proposition was that on being cleared of in the department of proceedings and the criminal proceedings, which any initiated, the employee to have a right the employee would have a right to be allowed to enjoy the benefits of the promotion if he was found fit on his own term. Next paragraph. In the present case, it is not the case. It is not the kind of freedom. It is not a promotion. But it appears that the promotion that is considered only on the obligation that there was a public place registered against him. This is of the firm's opinion that people legislation this person cannot have the effect of denying him the benefit of a promotion, comma, when his juniors have been considered, comma, and have been promoted, comma, more so when another co-accused in the same police case had been afforded his due promotion from the post of constable to the post of. Accordingly, since it is an immediate position that there is no criminal case pending in any competent court of law against the petitioner and he has been exonerated in the Department of Justice. Commercial respondent shall take immediate steps to have the case of the petitioner considered by a selection committee comma, if necessary, comma, and if not already considered for promotion, and if effective, we promote the recommendation of the selection committee for promoting the petition from the post of ASIUB to the post of SIUB. It is made clear that in case the petitioner is conflict of promotion and is granted to take promotion from other things, shall have the effect of giving him seniority within seniority immediately over his immediate near in the feeder category. The petition accordingly disposed of no harm. We will make a little change here and there to be the interest to be paid on the process of considering the case of the petitioner for promotion and giving him the effect of promotion from a conflict to be carried out within a period of 3 months from the date of the Lords. It was can you take it? Yes,
Lordship, reason leaks at 418.
we'll have it when he.
Lordship, but anyway, Lordship, our instruction otherwise says that final PPO and GPO has already been issued.
You got the PPO number and the date.
Yes, yes. Lordship file affidavit one.
These records.
Subsection white number 108
10
108 211 222.
no 10182
Sorry, my
That is the
para 15 Lordship.
how is the final PPO when in 2025
Sure.
that he is asking you. Have you seen
74.
page 74?
Lordship, that was in regards to EB crossing, whether they can be relaxed or not.
So that whether if the EB proceeding, if the EB crossing is relaxed, then what happens?
Lordship, in
The
that regard,
PPO will increase.
yes, Lordship. But particularly to that EB crossing of that period, it has been submitted, given in the parawise comments that the application has to be submitted within 3 years, 3 months from the date when EB crossing is due, which the petitioner had not submitted. Because of which now, after a lapse of 20 or 24 years, it cannot be done since the authorizing officer who was then there, he cannot issue a special report. So in regards that, page 74 is the one letter from the AG.
So your stand is that because the EB crossing has no value now, cannot be done now, this will become the final PPO.
No, whether any relaxation can be done with concurrence of the finance department. There is a para with regards to that. It will be moved to the finance department in the last part of the para. Para 25.
You you have its service record with you?
I don't have right now.
No, the department has a service record.
Will have.
If there was nothing adverse to him, can you withhold the application?
Okay, the only ground there.
You don't need, he doesn't need to have a very an outstanding or a excellent remark in his APR to proceed efficiency. This bar is a bar where whether you are good enough to continue in that or whether you should be given one more increment. That is the efficiency of much. You know what is an efficiency bar? No.
It's
10, 20, 30, ED 40. What does it mean? 10, 20, 30, you get people who serve for 3 years. The increment. Then comes an efficiency bar. Someone says, no, this is an efficiency. If there's nothing adverse in state, watching of an efficiency bar is good. Unless you have got a TQ or something. You are efficient. What is your prayer? If your details been answered, then you can come back. Otherwise, we'll get
73.
If
2 weeks and everything.
heard Mr. Sonke contributing for the we don't have concept for the submitted. In the prayer of the petition, in the petition is for registration of his pension by granting him, by allowing him to support the efficiency bar in the year 1990. The case of the petitioner that if the petitioner had been allowed to cross the efficiency bar in the now, like the Panchayat and Rural Development Department by next 21, that is the order that the petitioner did not find in time or him not to go. Therefore, this wrong, but if one possible time it must be to be that what therefore, there And also verify, if the department has any record available, it may the petition to deny the petition, you have denied the petition, the opportunity to cross the petition department the which begin on the 26th of June. Tell us why he was not given the allowed to cross. If there was no reason. Anything is taking the clear of this. Yes.
Two matter, interrelated matter. But they call it experience kind. The petitioner, while he was working my lord, as a ethical sanction assistant. And there is a department proceeding and same set of evidence, same set of allegation they are taking with the hospital. So ultimately, one inquiry has conducted on people from all the put there, the inquiry will not very fast. But they proposed implement proposal of one implement. The proposal one, but they have given me two. But now that is done enough. By the same time, my lord, I got the I filed a, while I filed the first petition, that the bill was not my lord. Then during the pendency of this matter, a bill was rejected, and that rejection order for that is second. In the rejection order, the why they have rejected only one gone, only one nothing. There is no statement that it is honorary. That is the only line. Your lordship can list the second in petition. 1536. 1536. Page 58. Only one line finding that we were acquitted by the trial court. Date of some came in a pit. No, I have been till now there is no thing. No, you see that appeal means department and departmental appeal was rejected on the ground that you are not honorably acquitted. There is that order at page 58. No, that trial court order. Trial court judgment I have annexed, my lord. Page 56, my lord. Sorry, page 37. Page 37. Your lordship can be which 1536. Yes. 11. Page 27, my lord. Page 49, paragraph 27. Paragraph 27 of the my lord judgment. And considering all the above discussion, it clear that the fiction has not proved that case against the accused person beyond reasonable doubt. As keeping in the view that it has been discussed above, this court has no hesitant that the fiction has failed to miserably to establish the guilt of the accused. That's it. Anything it will be no mind. Your lordship can just check paragraph 56 on perusal of the case record after going through the evidence used by the prosecution side, no witness had fully established the prosecution case. So we have examined so many my lord witnesses, my lord. So, my lord, in word, my lord, honorably nowhere. Honorably word is not very in a definition is not there. It is my lord judgment law. There is a, very good judgment of our High Court. When it comes to then there is judgment of our High Court. Right from even same time. Negligence of people. Delegation of the people.
May I submit that? The earlier writ petition, there is another writ petition. In that writ petition, we have filed our affidavit in opposition. Now, this writ petition on the last occasion notice has been issued. And they have stating certain things, and regarding this lordship, we have awaited our instruction. So I may be allowed some time to file affidavit.
Earlier writ petition.
Yes, lordship. The pending writ petition. Lordship.
Earlier it isn't there, but the earlier writ petition is allowed.
Earlier, not earlier, lordship, the item number 38. 39, item number 39.
Your ground of seven in the earlier writ petition. Disciplinary proceedings there. This will go. It will follow. Right. In that, my lord, they have not denied anything, my lord. Simply said that he has not denied the acquitted. Even earlier, they only one para, my lord, their lordship can do. Affidavit which they have filed, my lord.
And lordship, during pendency of that writ petition, this appeal has been rejected, and therefore they have approached again challenging that order, lordship.
There is a specific order to file a details affidavit that has not been filed till today in the earlier case. In the earlier case, only they have filed that we have disposed of the item.
Lordship, we will file affidavit in connection with this writ petition, lordship, 2026. I may be allowed some time, lordship. And after filing of our affidavit, lordship, they have approached challenging that rejection order by this. After filing affidavit by us in that case, earlier 2024 case, item 39, they filed
Please
this
come to page 29
29.
of the earlier writ petition. Page 29, you have the show cause notice.
Yes, sir.
Page 29 is the show cause notice. Yes,
Yes,
extra
sir.
5. Do you have it?
Yes, sir.
What is the first paragraph? You are requested to show cause as to why any of the penalties should not be inflicted upon you.
The logic provided inquiry put only two parents.
Can there be a show cause notice why I did not penalize you? They have already held in.
The in inquiry put only two para, small para. The logic go by the page 32 minor.
We'll allow them to file the affidavit in the second one that they.
I know.
Elaborate.
First one goes file of the which anyway, my but specific definitely because already my that the man is going to be there.
We'll take it up on the 25th of June.
My lord, okay.
25th. What is the amount of the senior counsel back? Preparing for the petition. You are paying for someone?
No, not that.
You change the case for the petition. By an earlier order, this court had required the petition to be filed. If however does not come from the first, in the petition in connection with the petition of 3184 of Procedural. The learned counsel for the PTC has paid for an accommodation to file an affidavit in WPC 1536. Accommodating is a request from a this matter again on 25/6/2036.
Yes, sir.
By which time the respondent should ensure filing of their affidavit in the petition. Petitioner will be at liberty to file their reply to the query and attempt to be made to consider the case of the petitioner regarding the disciplinary proceedings conducted against him on the next date fixed.
Obliged.
Yes,
Please apology, I like to mention item number 62 minor, I'm not feeling well. That statement I have informed Mr. Gauhati minor. Let it be on Friday or Wednesday.
yes, sir. Friday? At the
Friday.
request of the learned counsel for the respondent from by the each
And partner.
matter again
Already
on
partner.
no, 29th. 29th of May 2022.
As partner. Alright.
What happened is, this man was, the petitioner was engaged by the American Assam Mission Director. So now on his joining, before he could join, perhaps he started suffering from some anxiety and depression and all that, and he could not come in. He has made a prayer that he is going to be granted a interstate transfer. This interstate transfer is beyond the hands of the American Mission Director Assam. It is all under the Department of Health and Family Welfare. Wants to serve, but with the type of illness may not be here. Can the central government take a call to see whether such a transfer is permissible? If yes, who is the authority? We'll dive into approve that particular authority if they agree, and if it is not at all permissible, because it will be on a state to state basis. We just need that information.
Flush.
Only on your interference, we may get.
Yes.
But the learned counsel is paying for the party. The sport has requested the faculty service and the deputy SPI to have instructions as to whether the petitioner who was appointed under the National Health Commission Assam by the director of the NHM Assam to be considered for an interstate transfer or accommodation in another state. Since he is not in a position to discharge duty due to his illness, here Please,
Lordship, we'll keep it on Monday.
Monday. The matter will be relisted again on the 1st of June, allowing the director to have it. Lordship. Mr. By Mr. S. Give him an extra copy. Give him an extra.
I've requested him for a soft copy.
Yes, Mr. Guru.
Kindly those three order, last order. Respondents are required to update the records. For the rejection of my representation at page 19, in simplicity, by the no reason whatsoever they sign. Court minus directed while passing this order, whether the applicable, about the speaking order.
But yes.
Yes, where is the PO, the board of officers? Discussion. Nothing.
Already extension was granted in the previous.
All said and done. Your stand may be totally correct. The board of officers has to discuss it. Yes? Or is it a note put up, rejected? All sit down and sign. Who took the decision? Not the board of officers. Someone else put up a note. Is that the way to dispose of it? Dispose of the representation of a person whose wife is suffering from psychiatric disease.
But not anxiety and depression, and anxiety and depression doesn't come within the specific category of ailments.
Category of what?
As per the
Pending order.
standing order, page
This order is one part.
36.
There's anxiety,
36.
depression with hypothyroid.
7 ailments are included in this
Have you
category.
seen it is by the Department of Psychiatry? Page 28.
On this ground, he was already granted extension in the previous
Who
year.
took the decision that he will not be allowed another extension?
Already 4.
Who took the decision that he should not be allowed another decision is the only question, madam. He gave an application to Santosh. You file a petition through our NIS system. Yes? And then someone sitting there will say petition allowed and petition not allowed and put up the file before us. We will sign it. Are you happy? No. What should be done? Take a printout, put it before the board of officers. Board of officers will write down. All aspects considered, not feasible, rejected. Yes? What's the thing?
But on what basis it was rejected, it is certain in the.
Top of the DIG establishment director. Show us that one piece of paper, board of directors presented on this date. Board of directors rejected this date. Yes, they have applied their mind. We will assume that your board of officers applied the. Only that applied. That application of mine, we want to say that someone looked into the paper. Or that all these reasons were there in that file which was put up before the board of officers. Just that much. Is it there with you now? You'll have to wait for that.
As per, as per, SC Saxena case also, he can file representation after joining the,
Once he drops everything, he leaves his wife here, he leaves his daughter here, he goes there. Anything remains.
but as per this judgment, SC Saxena judgment,
You,
he needs to.
unless you have your affidavit on record, would you be able to reply no?
It is ready, Lordship, but since we have, this instruction, therefore it is not fine.
Then we'll record why we are not satisfied with the instruction. That we can. By the order dated 18/5/2026, the learned counsel for the respondent was required to produce necessary records in support of the order passed by the authorities concerned, rejecting the representation preferred by the petitioner as reflected in the order dated 10/2/2026. The learned counsel appearing, Ms. R.D.B., learned counsel appearing for the respondent, has presented a letter addressed to the Paris cell of the group center, Gauhati, whereby the reasons for rejection have been enumerated in the signal cell of full stop. However, the record as required by the order dated 18/5/2026 have not been placed before this court to show that the application of the petitioner had been placed before the board of officers on a particular date, along with all the necessary documents, and that the board of officers had considered the documents and had decided to reject the case of the petitioner. The order dated 18/5/2026 of this court is clear that the necessary records were required to be produced. The reasons for not granting the extension to the petitioner could be many, but what is important at the present stage is whether the representation made by the petitioner had been considered by the board of officers in the manner it was required to be done.
Or it may be disposed of with a direction to submit a representation, press representation, and within the prescribed time limit, they will.
We will see whether we would like to see whether the board of officers are working in the manner they should be working on. So every time we send back a matter, they pass the same order, he's back in. The Santosh or whatever at the paper is very good. There is a mathematical calculation to be done. An algorithm and someone gets put it. Because thereafter the human aspect needs to come in. The application of it. When we are hearing a matter, we put a lot of things available in the net, available in the book. But ultimately we have to apply our mind to say that yes, this will be applicable, this will not. Whether that aspect has been done and is being done. Otherwise, just why the representative? That human application of mind. Can we leave it all to artificial intelligence? Probably not. If RTB is accommodated for a period of how many days?
For filing the application.
And for getting the records.
Next week, it may be taken approach.
5th of June, on the 5th of June, 2026, to allow her to file an affidavit in opposition as proposed and also to produce the relevant records showing the consideration of the application of the petition by a board of officers. In such date, the interim order passed by the shall continue.
I've gone through the affidavit lordship, and basically he belongs from unreserved category. Those 4 ladies, they entered under EWS.
And they were
And definitely lordship, their percentage was less than her. again got absorbed under unreserved.
How can there
That's
be
what, that's what I have examined that part. So his space vacancy in unreserved. Yes. Exceptionally. Item number 8 was.
Other one is ready for.
Other one was to be a file or affidavit. It is ready perhaps.
Then we'll on the 25th of June. 2 weeks going to file your affidavit.
Yeah, private respondents also here.
Right? Yes, post-it, another angle. Both unarmed and armed. In the approach to this petition and petition has been filed. It is that some of the candidates have been selected. After some of the candidates in the unreserved category have been selected, after they were called for the Viva public interview, as EWS category candidates and have got finally selected as unreserved category candidates. Such a process could not be adopted where a person wanting a face the benefit of an the reserved category was allowed to revert back to the unreserved. The General Counsel for the petitioner submitted that there are other possibilities to look for the conduct of that which have been pointed out in the earlier repetition. And both these repetitions are required to be taken up together so that an effective certification can be issued. Notice returnable 3 weeks. Respondent number 1 to 5.
1 to 5.
Being represented by the unit counsel for the state. Comma, no formal notices are called for on this. No formal steps or service notices are called for. However, requisite number of extra copies is first and the from advocate within a period of 3 days from today. Notice on the respondent number 6, 7, 8, 9, and 10. The visit to the respondent number 5, comma, under whom they have been appointed. So, the respondents shall ensure filing of their affidavit of opposition on or before the 17th of June 2026. The petitioner shall be at liberty to file their reply thereafter. It's your advice. Also, please the matter again on 25. Again, on 8th of June, 2026, the parties to ensure their appearance on their behalf on the next statements. Late appeal.
Yes, Lordship, in this letter is a removal from service, Lordship. And
Here you are
here,
the candidature. You are rejecting the candidature. No,
yes,
no, appointed.
no, a provisional appointment letter was issued. Yes, Lordship.
Rejection of the candidature on to that.
But here,
The provisional appointment.
here, district commissioner has no fault. Vishnupriya Manipuri is
Who has given the certificate? District commissioner.
district commissioner.
In that case, who had given the certificate? District commissioner.
Sent-
Whether the certificate is fake or not. It's not an issue.
That is factor and here it is not. issued.
It is the correct certificate.
Here it is central list.
So
it
they are
is
not in the list.
included.
We are not on there. Come down one step from them. The division bench has also observed. If he has not been appointed on the basis of anything to do with the OBC certificate. On the merit, respondents were not been able to show that yes, he was considered as an OBC category candidate. Therefore, his appointment cannot be interfered with by you. You can deny him all the benefits of an OBC category candidate during his service. But when he did not use the certificate for getting a job. How does it matter? If he had taken relaxation in age, that is the only relaxation he can take, no other relaxation.
No, it is not.
OBC, there are two relaxations. One, the age. Second, if you are not on merit, you will be considered as an OBC, correct?
Yes.
Here he has got it as an unreserved category candidate. Meaning he did not take any benefit of the OBC. And whether it is a state OBC, central OBC, international OBC, how does it matter?
No matter.
How can you take away the bread and butter of a fellow?
Other allocation allocated for unreserved category. Recommended for unreserved category.
We have given you this judgment so that you can have a discussion with your clients before you file the affidavit in opposition.
Allocated.
Otherwise, taking away the job for such a long time will entail in what? Illegal termination, meaning back wages for no work received. Reappoint them. Happily take back the job, they will not ask for a back wages. But the request of Mr. as Bureau of Responsibility for the again on the will give you some time. 13th of July, 2026 to file the response to the petition. And I have submitted that the petitioners did not avail any relaxation available to the OBC category candidates and were selected both in their eligibility and in their merit as unreserved category candidates. Full stop. It is also not the case of the respondents that the certificates produced by the petitioner were either fake or forged. Full stop. List as that before.
Worship, in this matter, it's a transfer matter and the wife is supposedly not keeping well. Therefore, the court directed that she will present herself before the composite hospital and the hospital authorities will give a report. Nasil Kak, I have not seen it, it is there, Lordship.
This is by whom? So the husband is transferred or the wife? Both.
different.
No, no, wife is not true.
The wife is allegedly suffering from. Can you have one of them?
That is called uterine invalidity. If some operation your lordship because of the age of the child, 1.5 year, they have not been able to do it. That's the ground, we are taking the safe place, or your lordship wife will be allowed to be there till her operation.
Did we open it or could you open it? Yes. Will you reminds us of that magic show where they say that
I
you
don't know.
think of a card and
I thought they would be giving me a copy, but
this is reminding us of that magic trick where you think of a card and it is brought out from that sealed envelope. Is there no scope where they can be accommodated for a certain period where they can undergo the treatment?
that no.
Is there no scope where they can be
that is-
accommodated?
That is what I had submitted on the previous occasion. There, in every group center, there is a composite hospital.
Yes, yes.
So if it is there, then
If both can be accommodated for a certain period of time that you undergo the treatment, thereafter, move up to your destination.
This was the case and we take the hospital to be a type of hospital.
Are you ready to undergo the surgery? Are you ready to undergo the surgery?
Yes, we are not it. Only or not only I need.
On the earlier occasions, it is reflected that you had refused.
No, your lordship, because of the age of the child,
Now the child is a major.
not matter 1.5 year.
I'm sorry. Now the child is good enough to for you to undergo the surgery.
Just for 2 months, your lordship, I can get. By that time, he will be 2 years old.
So now it is May ending. If you can have your instructions to be retained till July,
I'll do that.
till July. Or we can ask for an affidavit, this and that and that, and it will be again July. So let it be July from your end. Because the report, without the draft report, the definitive cure is hysterectomy. It is a selective major gynae surgery and requires proper preoperative evaluation and preparation, including hemoglobin. That will take about 3 months. Have your instruction details, if they can be accommodated here, there, anywhere together for 2 months. Allowing the. Yeah. The opinion of the medical board is represented in opinion number 2, which defines that the petitioner number 2 is required to undergo an elective major gynae surgery with proper preoperative evaluation and preparation, including hemoglobin induction. The board has noticed that on the earlier occasion, the petitioner has refused surgery, which the learned counsel for the petitioner submitted was because of the tender age of the child. The learned counsel for the petitioner has submitted that given his opportunity to undergo the surgical process in the in the company of her husband, he will undergo the process. The learned deputy SBO has agreed to have instructions together If you petition can be protected within a certain unit to facilitate the procedures and also to time take for which we can take on. It's a matter again for
I can, let it be on Monday.
on the first of the order appeal movement. Order, now you got the for the past earlier. Stating the reasons of
Final prayer. Some subsequent developments happen during the payment.
Mr.
Case under
is continuing and responsible to paying for the petitioner, which is there. Development. Yeah.
483 bail application law.
And then and the FRA, they pay 16 letters.
1/6.
Yes, ma'am. Therefore, the arrest on whether 8 of December 2025. And as on date, 168 into 3 days.
I have looked into the scan copy, but the 183 statement I have not found. It need to be called for law. And moreover, I have also noticed that their search also may have been framed, but in the for the scan copy, it has not been there. So updated status report lottery along with the 182 statement.
The victim's statement is not there.
Lordship,
Victim statement,
but I have not found. 183 statement is not there.
High Court has rejected the bail also on the ground of the victim's statement.
but it was looking to it for once. Were you following her around? Are you following her around here and there?
But they're, I don't know. Like they're doing it. They're- If there is a college going 10 million and if you tell it 50 million, he's a first grade.
He is younger to her.
Kind of.
He is younger to her.
No, but
You are saying that.
no, I'm college going, my lord, and he is just first grade. I am,
You are college going.
I am 20 years.
So without an income.
College going. Technology. 183 technology, could take effective in the plastic also.
Where is it?
I have not found in the.
It has been submitted that the 183 statement of the victim is not available in the case records. Accordingly,
Updated case status may also be called.
accordingly, call for the updated case status. Updated status of the case pending before the learned trial court, along with a copy of the 183 statement of the victim recorded. Full stop. Ms. Agarwal, Dr. Agarwal, the learned amicus curiae has submitted that the learned trial court has rejected the bail petition of the petitioner on the basis of the statements made by the victim under section 183 of the CRPC. Full stop. Please again on, we'll have it on 5th. 5th or 3rd?
It will be better.
Taken the.
It will be common, not from wrong, yeah. It will be better.
5th, 5th of June. 5th of June, right. Okay. Any progress in the investigation, sir?
Investigation is going on, Lordship, but
Huh?
one thing I want to state here, Lordship. 183 statement is also there. Victim was there, but she escaped, Lordship, and she has not gone missing on 18/3.
The victim?
Lordship. Yeah. Report on missing. It is there, 18/3/2026. Missing report is there, no?
So fine. I didn't meet him.
Actually, she was from Gauhati. She was there found in the Soigao Lottery. This accused petitioner took her to that place Lottery. And from that, she has been given to for resident. But in the meantime, she has been missing, escaped.
From?
18/3.
Escape from where?
From she used to go to Lordship, the urinal, then she escaped.
No, from where? From a parent's house
No,
or?
no, from CWT Lordship. That is why I want updated CB law.
She was in Gauhati, my lord.
Moreover, if I look into the 183 statement, it is clearly stated that this person is with this person. The victim is with the present petitioner. Other person is also there. That is Safiqul Islam.
Both of them.
And if I look into the city lordship, she has one auntie's name she has taken lordship. She stated that go with him. But the father, mother, they are not aware of this thing. That is the case, lordship.
Where is the auntie?
And she is not accused.
She is not the accused.
Then
But she is not aware of the husband, lordship, father and mother, not aware. That they,
some auntie tells. But the auntie is not.
not lordship. And moreover, lordship, she has stated that she left, she was with that person also. These two person. And in the morning, another person came to that place and disturbed her lordship, tried to rape her. This kind of allegations are also there.
Okay, what is your story?
My lord, my story is that it is known to them, this family. And my lord, this auntie has get involved with the uncle who will bring you. Other, and next day, same day, my lord, when she was detected by the police, then it was handed over to her.
Why did you take her?
But there was no malice, there was simply.
Why? Your young child is handed over to someone. Please take her and they take her.
No, voluntarily she went to our Devita. We have not taken away when
See,
lady
sir,
had said that
sir, let us understand it this way.
My own
What is the
friend
age of
said
the victim?
12 years.
12 years.
12 years. You are 22 and 30 years.
That's true, my lord, but
Why would a
that's
12-year-old go?
till today, my lord, I think you not sure has been federal to that. But there is nothing. Like no.
He took her to his house,
Bad
lord.
intention is nothing is there. And the lady who was handed over, she is not in the picture. And moreover, 75 days we have already spent behind the bar method. 71 days, sorry, behind the bar method. And I am surprised that how much
The records are missing from the file.
Records are not missing, sir. The girl is missing.
Girl is missing, not record.
Where is that? No,
I don't know. It is in the record. that
okay,
it is-
she has been handed over to our parents.
No, no, no.
Not to the
It is
parents. She
not to
was
the
handed
parents.
over to the CWC.
Not she.
Yeah.
And now CWC says she gone to UNL and she's not there with us.
Not
She ran away.
Then, my lord, the DWC is a very important institution of the doctor of Assam.
Any auntie's name, address, nothing there.
Nothing. Name is only there, Lord. Let me look into that.
Now, my lord, our only prayer is a detention period. Nothing is there. We will face the trial if it is charged. 71 days.
Actually, they were caught in the village lordship in the Toigao. And that is the place of the petitioner. And other persons, the villagers, came to know this, they could get suspicion lordship. And they took them to the police lordship.
And this child is again missing from the house.
Lordship.
She's taken a very sad turn with the child missing.
That is the witness statement. In the last few pages, the child got missing is there.
After you lost your injection, whether there was any further.
Any further after that? What was the date when we
It was
rejected it?
23/4.
23/4. I think there's nothing after 23/4. Huh?
And she got missing on 18/3 lordship. 18/3/2026. She gone missing. 23.
71 days.
18/3.
19 days to go.
19 days.
19 days to go.
Only for festival.
Will you be able to win?
I will after 12 days or like that.
Huh?
I will try to communicate also.
Under any condition, I will take the trial.
Maximum second. We'll have it on the second. Let them try to face the colleague. You are behind bars. We understand you could not have a role to play in her disappearance. We understand that. But the kind of statement that she had made, and perhaps if she has now gone missing, we do not know whether she has gone back home or that auntie has a role to play in. The auntie who asked her to accompany me. We'll have it on the second. We'll take a decision. Huh?
For the 45, what do you think of the situation remain the same, the railway in the aircraft?
We understand now.
Not the investigation, only the recovery of the girl is question. Recovered and ended about.
Not only the recovery part, the auntie part also has to look into. No, viewed in that manner, the bail cannot be considered. If you go only by her statement, the only reason we are trying to keep it on the second is if something positive or if something the thing comes out where we can try to see whether your release would be detrimental to the investigation. Otherwise, with the statement that we have before us, we can reject it again. Now. We can reject it right now. Because the girl has gone missing. Yes. Once you are arrested, suddenly the girl will go.
It is not possible.
You'll have to think both ways. That is the only thing. List on the 2nd of July. The Learned Counsel for the petitioners have submitted that the petitioners have already undergone 71 days of custody. The Learned Counsel, the Learned Committee has submitted that unfortunately the girl is missing from the 18th of March 2026 while being transferred to the CWC. The KPPC have specific instructions as to the progress, any further progress in the matter, and whether the custodial interrogation of the petitioner will further be required in the given facts and circumstances. Once you cannot keep a girl who is with you, she was with you. She goes missing from your hands. They are with you. Can we trust you? They'll go missing tomorrow. Second, June. July. Correct. July nobody. Yes, sir.
After getting hearing order, by instruction, he get to the investigating officer subject to
Then you are on interim.
There is no addition against the present petitioner. The appearance of his brother was elected in connection with the pregnancy. That already report is also there.
Yes, sir. What do you say?
Yes, Lordship. His statements are there. That is a different thing, Lordship. But the materials, I want to go through the materials, Lordship. The person, for that, I have to go through the seizure, Lordship. What they have found, Lordship, 1,75,000. 6 numbers of PAN cards are there. ATM cards, Lordship, 34 numbers. 34 numbers of ATM cards. PAN numbers, Lordship, PAN cards, 6. And so and so. And while investigation is going on these 3-4 persons, they have stated, Lordship, along with others, this person's name is also there. And one of his brother is also named. And they have supplied this person, according to this person's, Lordship, arrested persons, according to them, that Procedural and Lordship, other persons are this Rokibul, then this Babul. Babul has given this ATM cards to this person, to all these 4 persons, arrested person. And their job is just to take out the money and give it to this person's, Lordship. This Rokibul and this person. And this person also, Lordship, the present petitioner. To collect the money, they deposited in this ATM, Lordship. They collect this money and give it back to this person. And they deposited in other transactions, Lordship. So in this case, Lordship, then this firstly, Lordship, that these persons, Babul and Asiks, the persons who have been arrested, they also have connection with the Pakistan, Lordship. In the investigation, it has been come up, Lordship. And what they do, Lordship, they collected this money from various mule accounts who have been found. The victim has been there, and these ATM cards, they use these ATM cards, accounts, and they then deposited to crypto, Lordship. They make fake accounts, fake PAN cards, and use this for crypto investment, Lordship. Moreover, and many other also they are doing this links, Lordship. And what the present petitioners, he is not named only by his brother. He also one of the thing, Lordship, he is also doing this.
Brother has named him.
Brother has named him. And not only brother, the person to whom he has been using as a Lordship mole. That also person stated that he used to give money 1,000, he take 1,000 rupees, Lordship. And for that, he do all these kind of things, Lordship. He also stated that he has to provide this ATM cards, Lordship, informations of these various victim persons, Lordship. He is fully involved in this case. Moreover, there are other cases also, Lordship, in Mikir Bhatta, 95/2025. The other persons, Umar Rasidul, the same persons. The same person in this case, this is Mitir Bhatta 103/25. And in another Mitir Bhatta, Lordship, 95/2025, these persons are the name. They have shown arrested this person. So there is a nexus, Lordship, whole nexus. They are looting, Lordship, crores and crores of rupees. And their transaction I have seen, Lordship. Lordship, last thing to substantiate my message, Lordship. The account of that person, the mule person, Lordship, who has stated that he has engaged this person, his account he has, and it has been seen 50,000, and he also take out the withdrawal is also there, deposit also there. Here now he has not shown the source of this income, Lordship. He has stated that this person is given him. And after his arrest only, Lordship, there's a big nexus, Lordship, going on all over Assam. So it is very, very, Lordship, important to have this person custodially integrated, because many other persons are also there. One by one, police is arresting. One by one, the investigation is going on. They get the person, another person's name, again investigate. So it is very important, Lordship, for his custodial integration.
But it has found my name, that's very thing. And during second versus that time on last video was that they improve your concept that face actually of paragraph 13 only that part. Paragraph 13, right?
Saying what? Alleged confession.
No, because from Grievances versus my submission is that apart from Procedural, there is no material that shows that those reports are coming. Apart from Procedural statement,
No, we do not take them as a confession. We take them as a plain, simple statement of persons who were arrested, who says that you have been the source of money. It is not about confession.
I think that's the that I am not.
Otherwise, if we understand this paragraph 39 in the manner you want us to, there will be no co-accused. There never will be any co-accused anywhere. Because someone has to say, yes, this man was there with me. You can't arrest him. Those things have been found from your room.
That my brother was there.
Brother and you both were in the same house. Your brother is carrying 34 PAN cards. Your brother is carrying how many? 60 something ATM cards. All of them together you are staying.
Moreover, Lordship, one thing I want to that other co-accused, Lordship, they are one Babul Ali. He has operating, Lordship, 168 bank accounts, such bank account.
168 bank accounts being operated.
Lordship. And Asikul operated, Lordship, 74. So there 161 is there, Lordship. It is because of that conspiracy is there. 61, 2 is there.
think what should like and verify when the case what my understanding is that from my brothers those ATMs were recovered. Page 26, I have given the forwarding info. Forwarding info is nothing.
What is the consequence of an anticipated bail petition being rejected?
That,
What is the actual consequence? We overlooked that consequence. We tried to have your statement recorded. Now they have got sufficient materials where your custodial interrogation may be necessary. Should we hold back their hands?
also when your doctor detected, there are some material that were.
What was the, what,
That material,
no, he has now come up with materials.
Statement, there is. Well, even if you have to be safe, but those were safe. Also, parents of my brother, whoever it says that you were recovered. And whether it was actually recovered from my brother or not, or from my house, that will not be verified. So there are a number of things that there.
If you see, now we'll go by your page 27 para 3. You saw us, you showed us 26. We have a look at 27. Incriminating materials related to the offense have been recovered from his possession. Heard Mr. A. Ahmed and a counsel appearing for the petition. Also heard the learned APP first. This is the second bail petition under section 42 of the BNSS 2023 in connection with Wikipedia PS case number so and so, page 1 of us. The earlier bail petition was, the earlier prayer for the grant of privilege of 3 years bail had been rejected by an order dated 22/1/2026. By an order dated 23/3/2026, this court had granted an interim protection to the petitioner, allowing him to appear before the investigating officer. Stop. The learned APP has produced the case diary and has submitted that there are enough materials available after interrogation of the other co-accused who were arrested as well as the petitioner that a custodial interrogation may be that a custodial interrogation of the petitioner would assist in the investigation of the case. We have also produced the materials relied upon by the learned APP. The submissions of the learned counsel for the petitioner that statements of a co-accused cannot, confession of a co-accused cannot be it cannot be looked into at the stage of anticipatory bail or even for granting a regular bail. Has also been taken note of. Stop. The apex court had held that there should be other materials which could be relied upon before such a confession is taken into account. In the present case, we find that there are material recoveries and the investigating authority has been trying to trace out what did you say? It's a big operation, or what did you say?
Financial network, or not cyber network operation.
It's the cyber network operation which has led to the siphoning of substantial amount from unsuspecting victims, etc. Full stop. In the present circumstances, we are not of the opinion that the petitioner can be allowed the privilege to continue with the privilege of a pre-arrest bail. So accordingly, this bail petition is rejected at this stage.
If you say regarding pension, my lord, what happened, my lord, the petitioner submitted pension paper, my lord, after 7 or 9 years. That's why, my lord, pension rule 205 and 206 is applicable. That's why he has to obtain a order especially from the government. So as per my instruction, my lord, they have submitted twice to the, my lord, his pension paper for account general. Now we are waiting for, my lord, obtaining the orders of honorable governor under rule 206.
Is he being afforded his provisional pension in the meantime?
No, my lord, his pension, he was a mentally disorder person. He was ultimately compulsory retired, my lord. So he did not submit his pension paper.
Provisional pension, once there is
Provisional
a-
pension, my lord.
once compulsorily retired,
Yeah.
it has to start with the provisional pension. Our order dated 11/3 shows that the provisional pension
Yeah.
has not been received from August 2025.
That is, my lord,
Can your assisting counsel have that updation?
no. Yeah, whatever.
Yeah.
Even the pension, my lord, rule 205. Provisional pension is-
Huh?
Still,
He was doing his provisional pension,
yes,
but it was stopped. Because it will be, we'll have it after some time. We'll see if the petitioner's counsel comes. He may have the information whether the provisional pension is there or not.
oh, my lord, the petitioner can say, my lord.
After some time,
Not whether he will come or not, my lord. No guarantee.
we are giving that opportunity to the respondents all the time. Why not one
No,
response?
no, I'm not opposing it, my lord. I doubt it whether he will come. So let us see.
Yeah. Huh? Hmm.
He's for hearing that, my lord.
In the meantime, in my office, you can submit the repair on
I think so,
During the pendency of the disciplinary proceeding, he is retired.
has been closed. And he was stoppage of 4
Ah. Yes, sir. Why the provisional pension is not being afforded?
My lord, provisional pension.
Now they say that due to pendency of the judicial proceeding, the
Any written instruction on that?
yes,
Mr. Sutia,
I have no instruction.
you have to know, no, he's producing a letter signed by someone.
communicate to me.
Huh?
I don't know, my lord.
Communicate to me.
Perhaps they know you will not appreciate of this letter and therefore they have not given it to you.
Most
Hmm?
probably. I have no such letter.
You are giving us the wrong impression. They had processed the pension paper, they will say there's no provisional pension should be done.
But till today, I have not.
That's what one I. If I agree with one detail, that's the whole right. The one I got.
Heard Mr. S. Bhattabur, Learned Counsel appearing for the petitioner, also heard Mr. J. Sukia, Learned Senior Counsel appearing with the assistance of
All the respondents.
all the respondents, but with the assistance of sir
No, all the
H. Chakraborty, Learned Counsel for all the respondents. Full stop. The parties have submitted that the pleadings are complete and the matter can be taken up for disposal. Mr. Accordingly, leave this matter again on when 4th of June, 11th of June, 11th of June, 2026, full stop. The learned counsel for the petitioner has submitted that the petitioner, although had retired on the 31st of January 2026, has not been paid his provisional pension. Full stop. The respondents would ensure the payment of the provisional pension at the earliest. And it is clarified that the pendency of this petition shall not be a bar for the respondent authorities to provide either provisional pension or regular pension to which the petitioner may be entitled. If he wins the case, then his regular pension will go up. Yes. Otherwise, you can pay regular pension.
Obviously.
We have filed our affidavit.
When?
Okay, we have filed our affidavit.
On 22nd. Are you granting them the benefit or are you not? What have you said in the affidavit? Joint director is respondent number what? 3. Affidavit filed on behalf of respondent number who?
2. Director of Health Services.
So the director will not defend the joint director. Show me the affidavit. The learned counsel for the respondents have submitted that the petition. Respondent number 2 has filed an affidavit in the matter. Where is it stated? From the although it's been filed, affidavit has been filed with the good one, has been filed on 22nd of May 2026. Although the affidavit is not found on record, the copy of the affidavit has been submitted before this court by the counsel for the respondent number 2, where a specific stand has been taken, from where it can be deciphered that the Joint Director of Health Services, Dibrugarh, had caused a delay in regularizing the period of absence of the petitioner, and therefore the pensionary benefits of the husband of the petitioner of the petitioner has not been paid. Full stop. Of the husband of the petitioner has not been paid. Full stop. Even the compulsion of family pension of the petitioner could not have been processed, due to the lapse on the part of the Joint Director of Health Services, Dibrugarh. That is what the affidavit says, every paragraph. Yes? Yes. List this matter again on 24th of June 2026, by which time the Joint Director of Health Services, Dibrugarh, shall invariably file an affidavit showing cause as to why the delay had been caused in regularizing the period of absence of the petitioner. Full stop. In case the aforesaid period is regularized, the same may be indicated in the affidavit along with the date of communication of such regularization to the respondent number 2. Full stop. In the absence of the specific stamp of the Joint Director of Health Services, which said the incumbent holding the said post shall remain present before this court, may be called to remain present before this court by an order passed on the next day of the Hello. If the GIS is retired, you did not, no disciplinary proceeding, na?
Nothing, is entitled.
And this kind of affidavit from one officer blaming the other officer is going to create havoc one day. Yes. What is the grievance?
He has not get the 2 pensions lots.
Huh?
She has not get the 2 pensions lots.
2 pensions.
2 pensions.
Why should she get
To
2
claim
pensions?
Both. Claim both pension.
Why are you not giving her any pension?
Not one she is getting. One is
Which one?
father.
Father. So that she has got now.
No. In our affidavit, lots of kindly peruse the
Why not the mothers?
And listen, there are 4 lots in our affidavit in opposition.
Ah.
I'll better respond number 6 lots. May I read lots? Para 4 lots.
You are choosing the longest paragraph. Yes.
Lots. That in that, the deponent begs to state that by letter dated so and so dated 2010-23, a clarification address to the Accountant General Assam was issued regarding unmarried dependent daughter family pension under Rule 143 Sub Rule 1D as per provisions of Note 2 under Rule 141 Assam Service Pension Rules 1969. When both parents who were government employee die, only a minor child is entitled to receive 2 family pensions up to the age of 18 years in case of son and 21 years in case of a daughter. When child attains majority, that is 18 years in case of a son and 21 years in case of a daughter, family pension ceases to be entitled to them. However, in case of daughter,
Which rule do you say?
43 1 sub 1 Roman 1 D lots.
আর নহলে অকমান হেৰি কৰি দিয়ক 25-26 মান কৰি দিয়ক 143 1
Roman 1 and D lots.
There is a technical problem in the chamber. In the morning, there was no technical problem. I saw him there in the morning. I saw his name there in the morning. 143 1D. D lot. Where do we find it? 143 1D. Unmarried dependent daughter.
Unmarried dependent daughter.
Ha. As per note 2 of Rule 141, note 2. Of 141. Yes. So a minor child is allowed, but an unmarried daughter is not allowed.
Up to the 18 years. Up to 18 years of
Why is a minor child allowed?
As per notification lots.
Which one? Which notification?
No, not as per the rule. So rule
Rule, what does it say? 143 1. What does it say?
140.
Minor
Minor son up
and
to 18 years.
and similarly like minor son, what is said? on the top, unmarried dependent daughter.
Dependent daughter. That's it.
So where do you find this minor children part?
Now she is getting one
Where do
pension.
you
Lordship.
find the main minor children part? Tell us.
And she is getting one pension. Lordship.
So a minor son is equal to an unmarried dependent daughter as we are understanding. If a minor son can get two pensions, equivalent status unmarried dependent daughter, why will she not get two? Give us that logic.
Next day,
Don't go by the note.
on the
We
next
are
day,
not on the
Lordship.
note.
On the next day,
Note says children.
Lordship.
But a minor son has been equated with a unmarried
Unmarried
dependent
dependent
daughter.
daughter.
So long as the unmarried remains and so long as the dependent remains. The moment she gets a job of her own, remove all the no further. The moment she gets married, remove. But a minor son is equal to a unmarried dependent daughter. So it is not a case of minor children. Minor. It is a case of minor unmarried daughter.
dependent.
For further arguments when? For further arguments when? Tomorrow? Tomorrow? Tomorrow. This the matter again tomorrow.
Obliged.
That's part. Only that much we need to clarify. Otherwise, you don't have any other difficulty.
Last occasion. They were to do for the fiancés.
What is this case? Left tympanic membrane central perforation. Just a minute. Right tympanic membrane intact, left tympanic membrane intact.
Intake, that meaning not hold, not hold.
Intake means no hole.
No hold, not one, not ten.
Yes. Yes, madam. Where is your rejection? Your rejection by whom?
Review medical board document 46,
Page 46.
47. 47, 48. 47 is the type portion and 48 is
47. Yes, madam, you tell us from that specialist opinion from your report.
Lordship. We have sent him to higher hospital and he also found him unfit from the before this review medical board. After DME, we sent him to specialist and after his report, that was considered in the RME board. On two ground we sent him, but one found another is according to the specialist.
Where is that medical thing?
Lordship, that additional
Uniform medical
affidavit-
guideline? Uniform medical.
Yes,
guideline.
Lordship, and additional affidavit is there.
You have given?
Yes. In that.
What is the
affidavit-
position in the tympanic membrane?
Yes, Lordship, page 74. Clause 3. 4. 70, page 74.
Existing perforation of the tympanic membrane or history of surgery correct? of surgery, correct perforation during preceding 120 days. Not covered.
Existing perforation of the tympanic membrane
It is not there.
or
Or
history of surgery.
surgery.
The first part is there.
Correct
Lord.
perforation during the preceding 120 days. So there must be a history of correcting that perforation within 120 days.
That is or lordship, either or.
So
First
which one is
portion.
existing?
First portion.
Your this higher hospital says tympanic membrane healed perforation. And that is why we were so specific, because it may not be here, but we have read that it is page 78. General grounds for rejection might. Yes.
Left
Come to
lord.
page 70. Come to page 70. You remember reading this 9 years, 10 years ago.
Lordship. That I have seen.
Page 70.
Yes, lordship. That I
Seven.
have seen lordship. Yes.
G.
Yes. But lordship here, lordship.
Job. It's a job.
Left and right to two. That's here. Higher hospital is there. Right, the heel perforation. Left, the congested central perforation. And this opinion is that petitioner is unfit from ear side at the time of examination. LSOM lordship. Left tympanic membrane central perforation. That is the region of unfit. Right is heel. Left is not heel.
Oh, left is not. Where is your medical? At that point of time, you had a central perforation. Audiology report means nothing. Your hearing test should be fine. The difficulty is that central perforation between higher and
And this he is relying on this page 54. It says only about the right part. This certificate of GMC is only which he had annexed with the petition lordship. It's only about right. Left is left, but this is not. It's corrected lordship. It's some in the 54 page number. That is why
there are corrections.
yes, lordship, correction.
Tympanic membrane, then
Yes.
curtain intake.
Yes, lordship. And this
Shortly right PM. Shortly right PM.
but the page 54 is just a blank page. It's
Oh, he had written TM intake. Then he cut out the TM and he wrote on the top tympanic membrane.
but this page here no seal on sorry, seal is there, but in name of the petitioner is also not there. Only the
This
first
is-
page 50.
No, this is Page 53 is the back side of page 54. Sorry, page 54 is the back side of page 54. It's just the reverse. It's just the reverse. Huh?
But-
Either of the two is correct. Now, how to resolve it?
But review medical board lordship, the Supreme Court has also held that the review medical board, when there is the policy also says that review medical board is decision of review medical board is final, and the main ground is that you have to take the opinion of a specialist, which we have done.
The only problem here is this. Let me tell you. The only problem here is this: none of the medical certificates contain his signature, showing that he was the man test.
But name is there. In our document, name is there, Lordship. Name is there, and that is
the
not
name-
under challenge that it was
That-
not done,
That name is also here.
Lordship.
And here it says that it is intact. Here it says it is perforated. This is 1 month later. 20 days later.
The DME also found him unfit. DME also found him unfit. DME found, that is why we sent him to specialist, and then specialist opinion, and thereafter the review.
How do you say this is specialist?
He is Lordship, Dr. Manisha Bajoria, MBBS, MS, ENT.
Yes, sir. You have found unfit by the medical board. Specialist. Uh, This review medical board is done by MS ENT. Ear, nose and throat. That is the question of, that's the disputed question. Okay, you go once again to the GMCH on your own. Let us. We'll send him at this cost to the GMCH.
If he get pending.
If this pending, we send him to the GMCH. He will be identified with his whatever identity card he gives. The ENP department would look into him again, along with the production of these documents, then give their opinion. If they say there is no perforation, then it is separate. If they either say that this document is not correct, or there is a perforation, or there was a yield perforation even. In that situation, that okay, conciliation of the opinion of the experts. Otherwise, they had done the test.
And in that case, Lordship, because he has to take this higher hospital report also along with that, because it will be better.
Have you given it to him? Is there in the affidavit?
No,
You
no,
filed
if
it?
it is not filed, Lordship, or Lordship,
Huh?
let him go to the GMCS, let the report be.
Or you give him a copy of this? You give him a copy of this,
Lordship.
a photocopy of this report, so that he carries it along. But Mr. And a counsel appearing to the petitioner also, but this Bishama and a counsel appearing, learned CTC appearing for the respondents. The bone of contention in this petition is the rejection of the petitioner on the ground that he suffered from central perforation of the tympanic membrane of the right ear. The detailed medical examination and
Left
the-
ear.
Huh?
Left.
Of the left ear. The detailed medical examination during the selection process had found the petitioner to be suffering from tympanic membrane perforation of both ears. And during a review medical examination, the petitioner was found unfit because of left tympanic membrane central perforation. So it is the case of the respondents that immediately before the review medical board gave the opinion, the petitioner was sent to the higher hospital where he was examined by an ENT specialist who gave an opinion that the left ear of the petitioner suffered tympanic membrane of the left ear of the petitioner suffered from congestion and central perforation. This certificate was given on 2011-2023. The counsel for the petitioner has produced before this court the original records available with him regarding the audiology test, etc., conducted by the Department of Otorhinolaryngology of the Gauhati Medical College and Hospital, where the associate professor of the Department of ENT Gauhati Medical College has certified that the tympanic membrane of both the ears are intact. This is a certificate of 3/12/2021. In order to resolve the issue, the health, anybody from health is here? Get someone to Standing Council Health and Deduction running at the petitioner shall present himself before the head of the department, what was the department? Department of Otorhinolaryngology of the Gauhati Medical College and Hospital on or before the 5th of June 2026, with a request to the aforesaid authority to conduct with the request to the aforesaid authority to have the petitioner examined once again for the effect on the basis of which his candidature has been rejected. So the petitioner shall also produce a copy of its order of the court and the earlier certificates issued to the petitioner, along with a copy of the certificate issued by the ENT specialist of the higher hospital. The report of the ENT department shall be placed before the court on the next date of hearing to the Standing Council for Department of Health and Family Welfare, Government of Assam. Was this to reflect the name of the Standing Council Health on the next set of the state. Place this matter again on the 10th of June 2026. 12th of June 2026. Yes, health, just a minute. Mr. Lordship, in the case just prior to this, the Hyatt Hospital says the year is bad. The GMC says perfect. So we have asked the petitioner to go to the department of, the DNT department, GMCH, meet the head of the department, give both the certificates, have himself tested again, along with the order of this court. The report will be given to the court through you.
Yes, sir. Yes, sir.
On the next date, which we have fixed as 12th of June, your name to be reflected in the court. So that is just the earlier one.
Item number.
Item number 38.
Kindly convey a copy of the order of this court to the head of the department,
Yes,
DNT, so he can,
To Superintendent GMC, I will convey.
whichever way, just when he appears, when the petitioner appears, proper identification that this is the man and this is the test. That is all we know. Thank you.
Hello.
Yes.
Lordship, we got the instruction, Lordship.
That one part of the area family pension.
Yes, yes,
Area
Lordship.
family
Yes,
pension that she has not got.
Yes, Lordship.
What does 140, what does it mean?
What is?
Where do you find this paragraph?
Amendment one, Lordship. 143, amendment 143.
Yes, when did you file your first application for this family pension to the, huh?
In the year 2016.
In the year 2000, when was the first application filed?
2000.
Yes, sir, 2016. Where is that letter?
The reference has been
Show us something.
annexed, annexed A.
Annexure? Yes. AG. Pension and public grievance, who appears?
I am appearing on behalf of the pension. Public grievance.
Page 27.
Page.
What is the highest rate of interest we can put on family pension?
Lordship, now Lordship, what happened, Lordship?
Hmm.
Can you see in the instruction, the office will take necessary steps as and when the instruction will be received from the office of the AG Lordship. That is the position. We'll take the step.
He is acting with, in the absence of any compassion. He is acting without any passion. And therefore, this court will also now act without any compassion and any passion. We will go strictly by the law. 2016, the Office of the Additional Deputy Commissioner Nagaon knew that there was a claim for a family pension by a person who is a certified disabled person. 10 years, there is no process by the office. So therefore, our first question was, what is the highest amount of rate of interest that can be given in a case of family pension?
Lordship, Deputy Commissioner, Lordship, immediately after the application, Lordship, it was forwarded to the, it was.
Then why this reference to the first?
It is
The
page
first
27.
clause when they quote the amendment, what is the effect? Well, what does he want to convey?
That is Lordship, because at the time of, it is Lordship, it is the rule, Lordship.
Saying that it will be payable at least from 2016,
Yes, Lordship.
at least
Yes.
from 2016.
Lordship. At least from 2016. But his claim is from.
Now, you
2004.
also appear for the pension and
Yes, Lordship.
now you had received this letter in the year 2016, hopefully.
Yes, Lordship, but.
Thereafter, what has been done?
But Lordship, the department, pension and public grievances, Lordship, here, Lordship, the AG will do, Lordship. The pension proposal will go to the AG, Lordship.
Was it sent?
Lordship,
So the deputy commissioner, so the additional deputy commissioner Nagaon in the year 2016 made a mistake by sending it to the
yes,
deputy secretary to the government of Assam Pension and Public Grievances.
yes,
He
Lordship,
made a mistake.
yes.
Thereafter, he kept repeating the mistake in the next letter. Then he was told in the year 2016 that it should go to the concerned administrative department. Thereafter, what was done?
Now, Lordship, if, as and when the instruction bring from the AG, Lordship, will be prepared for area payment also. But it will affect
Who
from
represents the
2016 Lordship.
general, who represents the general administration B department?
General Administration, Lordship, the standing council is there, Lordship.
The new council.
Yes.
The Action Standing Council General Administration B department. That is the parent department.
Lordship.
Who should pay, who should forward the documents? Tell us.
The documents the deputy commissioner will forward. Lordship.
To whom?
Lordship, deputy commissioner, Lordship,
To whom?
AG, Lordship.
To AG.
Yes.
So he has not forwarded it till now.
No, that was forwarded.
Forwarded.
Already
Then what
family
happened?
pension, regular family pension is
Is
get
getting-
For the area.
Area.
for
Who
that
is responsible?
Yes, for that area, Lordship, for that area, Lordship, the AG have to give us the instruction.
AG.
Yes.
Why no proposal?
Lordship, thing is that Lordship is getting the pension with it, family pension. Lordship, but thing is that that application was received by our office on 28/6/21. And as per rule, Lordship, from the date of application or from the issuance of notification, whichever is later.
When was the notification?
Notification was issued in the year 2017, 18, Lordship.
Huh?
9 August 2018,
9 August?
2018.
He made his application in 2016.
Lordship, but we have received.
Then he made it. Date of application would not mean your date of receipt.
No, Lordship. We are.
Not your date of receipt. It will be the date of application. That means the date of making
Date of
the application.
application or Lordship, issuance of notification,
Ah.
whichever is later.
Exactly. So from 2018 at least.
Yes.
What have you done?
Lordship, we have received in the year 21. Lordship.
From 21 to give
And
him the,
21 he is getting.
from 2018 he's entitled.
Lordship, that entitled department will tell Lordship whether he is entitled or not. Lordship, we are only implementing agency.
No, sir. You received the application in the year.
28/6/2021.
Very good. He made the application in the year 2016. department caused a delay in sending it to you. Now, settle that he has to get it from 2018. Are you contesting that he should get from 2018 or not? Are you contesting it on principles?
Let's say if she submitted on that time notice, she's entitled.
Yes, she's entitled. Now, who has to say that please pay the area? Who is the first person to say?
Deputy Commissioner.
No, but the instruction should be come from there.
To do what?
Side. AG.
To do what?
So
What would the AG
prepare
instruct?
prepare the area,
Claim is to be received from the
yes.
District Department.
Yes, claim is received.
Today we will make an observation here that the Deputy Commissioner Nagaon will process the claim for arrear from the date that it is that the pensioner is entitled to.
Yes.
Within a period of 3 days from today.
3 days.
Yes.
3 days.
Yes, instructions. There are no instructions, there are directions.
But
Send
let's
it
say
on the next
1 or
Monday.
2 days between 3 days, let's say it's a holiday, let's say.
Okay, we'll add 3 working days.
And then Monday or Tuesday, like. Yes.
We'll have it on Wednesday.
Oh, that's all.
Show us the proposal
That's-
that you have sent to the AG.
Yes, Lord.
Yes?
Yes. From the date of receiving the application.
We don't know. You give us your calculation.
Lots,
You
lots.
miscalculate, it is to your risk.
Lord,
You correctly calculate, it is
Lots.
to your benefit.
Lord.
Heard Mr. So-and-so at council appearing for the petition. S.K. Chakma on behalf of E. Ghosh. Why? Your name is not there in the Vakalan Also heard Mr. Goswami, learned counsel appearing, learned additional senior government advocate
1 and
appearing
3,
for
Lord. 1
respondent
and
number 1 and 3. Mr. Talukdar for respondent number 4. Who appears for 2?
Lordship, for the GAD, I'm appearing with.
Online, Lord.
Mr. Fikon,
Africa.
online.
We are
for
we are a formal party.
The petitioner claims that the area of the pension to which the pensioner is entitled is required to be paid from the date of notification of such entitlement, that is the year 2015. It is the case of the petitioner that the application for grant of family pension to the pensioner was initially made in the year 2016, and the notification granting such, what is the notification regarding?
Regarding 9 August 2018.
And it's governed, and the notification dated 9th of August 2018
Issued by the Pension and Public Payment Department.
recites that the pension would be payable from the date of the application made or
Or from the date of coming into force of this notification, whichever is later.
full stop. Accordingly, the Deputy Commissioner Nagaon is now directed to prepare the arrear, the proposal for grant of arrear pension to the petitioner within a period of 7 days, 7 working days from today, and forward the same to the Accountant General for further processing the matter. Place this matter again on the 12th of June, when both the Deputy Commissioner Nagaon and the Accountant General, some acting to their respective councils, shall inform the court the steps taken for finalizing the arrear payment of family pension to the petitioner. Data? Have you challenged that one? Are you claiming under that OM? Yes, Lordship. Then can you challenge that OM? No, Lord. Get this area first, then we will see what is. Yes.
Obliged, Lordship.
It is very good. Dispose not about it. Yes, record. Yes. Tell us why it was granted to one person when so many others were like. What does it say? Tell us.
And I am ready for mediation, second round. Alia Lordship, 3 times Lordship meeting.
Hmm?
It may go for mediation.
Mediation under pressure.
Between them.
Are we coercing you into mediation? Hopefully not.
No matter.
Okay, you keep a scan copy of the records. Lord, kindly with you, so that you don't have to call it again on the. The learned counsel, the learned additional senior government advocate, Mr. Goswami, has produced the records called for, which are not produced at the moment. Mr. Goswami is requested to retain a scanned copy of the records for perusal of this court at a later stage, if so called for. The learned counsel appearing for the respondent number 5 has submitted, Mr. Mukhtar has submitted that the respondent number 5 is willing to undergo a round of mediation with the petitioner. You are appearing for? Then you take your seat for a time. With the petitioner to see if an amiable settlement can be brought to the issue. To stop the learned counsel for the petitioner does not object to the aforesaid offer. Sit down once. Now they know the situation.
Yeah, Alia Lordship, for 3 months.
What happens is this. When you think you are very on the top, and someone shows that the base is very shaky, then people tend to climb down. Sit down and talk. Always better if you can have it within the family. The parties shall therefore appear before the mediation center on date. Take a date. There are suitable date for yourself. When?
Second week of June.
On the 8th of June. On the 8th of June, 2026. To attempt another mediation stuff. In the event the mediation fails, let this matter be relisted along with the report of the mediator. Sit down, sit. This will otherwise shake everything. You also come down some bit. Part mediation done here. Yes. Which is 66. Yes.
There is a new development of this matter,
Lordship, so Lordship, can I return the original record?
Yes, I requested you to keep a scan copy.
Kindly.
The original records may be returned by Mr. Goswami by retaining a scan copy. Yes.
Development in this matter, which I believe has to be taken note of. I may invite page 17.
Page 1717.
160. Which is a type of. I mean, this one, I wasn't expecting this, but it came. Somehow, so I don't know how to do that. We'll certainly do. I mean, the government has filed an affidavit at 3:25 PM.
Today.
It's okay, perfect. Nothing. I consider the other thing. Say, they wanted to bring it on with me. Which says, in pursuance of the DHE letter number 2023, applications are invited to the prescribed format available in the website. The complete biodata and self-attested copy testing on HSLC onwards for eligible candidates are dealing with the following posts of assistant professors. We are concerned with number 2, geography. Now, the point number 1, very important. It says important point. So I read it very important. Over. The educational qualifications and selection procedure will be as per Government Office Memo number 24/1/2018. May I read again?
the educational qualification and the selection procedure will be as per Government Office Memo number 24/1/2023. 24/1/2023. My lord finds at page 27. Page 27. That's 24/1/2023. I mean, it sprang up with the affidavit. I want the booking of it. But now I have 27/1, 24/1/2023. May I read? In partial modification of Government Office Memorandum of 25/11/2020, issued by the Higher Education Department, the government of Assam in the Higher Education Department used to notify the following guidelines for selection of the assistant professors, librarians in provisionalized colleges and government model colleges of Assam. Eligibility qualification. Qualification for direct recruitment, assistant professor, reference so. Number one, now, good academic record as defined by the concerned university with at least 55% marks or equivalent grade in a point scale at the master degree level in a relevant subject from the Indian University or equivalent degree from the accredited foreign university. So, relevant subject. There were three interpretations as regards relevant subjects ought to be given. I would not address the courts in my favor alone. I definitely face the arguments and the judgments against me also. That will be fair. We are addressing an issue of relevant subject. Dealing with a lot of people before. Now, the first, as I understood, relevant subject, I thought my way of appreciating it, 24 January 2022 Office Memorandum applies to history, applies to Bengali, as well as physics, chemistry. So the relevant subject to the relevant post for which the advertisement is made. I thought it that. That's okay. Whichever post for the subject is advertised, the relevant subject will be that relevant. Then, when I was addressing this matter and I did my research, I could not know the views of the honorable expert and other was also. Other subjects are also there with the shooter. The one reason is that this will be there, but it will be good argument. Suppose at a major degree level, the subject of history is so major of history would be history. But a master's of history may be Assam history, medical history, modern history, Indian history. So master's in any specific branch would not entitle you as a relevant subject. It would be a relevant subject. I borrowed now this understanding, then geographic information relevant. It's like it would be relevant. But now the government is filing affidavit saying it's not a relevant subject. They say it's an allied subject. Out of the scope. May I? Not on record. I just this is just now. I just make it on record.
Now I know why it is called the professional vocabulary of words.
No, it's an allied subject. I was considering a relevant subject.
There is one judgment of the division bench.
Office memorandum closed the word relevant subject.
University.
They say it's an allied subject. I say geographic information science.
Relevant or allied?
Is an offshoot of this. I am not disagreeing to them. That was my starting argument. I am not against them. Yes, both are one and the same in the branches out. Then I place the judgment to show the distinction. But now the government says no, it's an allied subject. It is out of the OM, it is out of the OM, out of the advertisement. This has the sanction of the highest authority. So now the selection has to go. Until yesterday, it was only a relevant subject. Now they're giving the allied subject also. It was never there. My friend, explain me. In the case which I presented,
No. The opinion of the Dibrugarh University is also an allied discipline.
Allied subject. It's not relevant.
It's not relevant.
Therefore, there is no case. He has to go. And they cannot address the court because the government has taken a step. That's all.
Point number 2 of that letter.
Of?
Dibrugarh University. Page 57.
No. Whether they can be deemed eligible or not is the opinion of the Dibrugarh University.
Yes, point.
Whether
page 60.
as part of that was also the opinion of the selection committee. That is under challenge.
As
This
per-
is also the opinion of the selection committee that you can be considered, is it not? The same opinion by the Dibrugad University and the selection committee, that you can be considered for the post. Yes?
Eligibility is there.
So that is what he's challenging, that you are not eligible.
Yeah.
So in a way, that second clause is under challenge. We will not go into that. The first one says allied discipline. Government says in the affidavit allied discipline.
Advertisement says.
Relevant. There is one more judgment of the division bench of this court on this aspect. Have you tried to find out?
There are judgments against me also of the apex. What I'm on is that the doctrine of precedence and the doctrine of jurisprudence come in. Whatever judgment I have placed, against judgments are there to that value, 26.
There is a judgment of division bench of this court,
Then allied and relevant are same.
not allied and relevant, but having a qualification in history, having a qualification in Indian history are separate things. If Indian history was to be included,
Correct.
then it had to be there in the advertisement. If not, it goes.
That's what I'm relying on, not the judgment which I placed the other day. The Honorable Apex Court distinguishes the MCA and the mathematics, says that mathematics may be included in part of it.
This is mathematics. That case was history.
That was history. That's what I started up with history, Lordship, because
Mm.
when I was placing this Honorable Court on this point, I started up with history and the branches of history.
Justice Chaudhary on the first round and division bench. Disciplinary University.
But now
Come down.
they have been considered it's an allied subject.
Yes,
It has nothing to do with relevance. Sir.
allied and relevant are the same. You may be my ally, but you may not be relevant.
Yes. But this is what the expert has.
Now what to do? Selection is bad. You will take a decision or we'll take a decision.
We will take it. We will take it.
You will take a decision when? He is awaiting results.
With all humility, my lord, the selection is over, the gentleman is working, they cannot take a decision up to date of review. That's not there. The Act of 2005 don't give the power of review. Either lordship dismisses my petition or allows it. Because it is represented. And the government has played the card. They say it's allied. So now the other person has nothing.
You are saying it is allied, not relevant.
Yes,
Correct.
sir. So far,
Absolutely.
my instruction.
Yes, sir, allied and relevant.
As per the other experts, but that's the method is set by them.
Oh,
They have decided it's allied, not relevant.
it's allied, not really.
My lord,
It will be like sending it back again for an inquiry. Till the time I get the result I want, I will keep sending it back to you. In disciplinary proceeding, there is that concept. No? De novo inquiry till I have a report against you. Cannot do. They have said it is allied, not relevant.
That is my case.
my lord, that this observation made by the Disciplinary University, that's point number 2. That my lord,
Which in essence was
Yes.
also the reasoning of the selection committee when you were selected. Yes?
yes,
That selection committee's reasoning being challenged, being under challenge in this petition. The reasoning of the university is also under challenge. The same reasoning is under challenge.
this opinion was taken pursuant to the order passed by the Supreme Court. And this particular information when by the Deputy University that my lord, the eligibility for appointment.
He's against the law laid by the Supreme Court.
Lord, in Supreme Court, my lord, this judgment, my lord, 2014. In that case, my lord, the appointment committee, they said that for NCA, mathematics is not the relevant. Here, my lord, the Disciplinary University says that the eligibility for appointment as assistant professor in geography is granted to a candidate holding master's degree in geographical information science.
There the Supreme Court has said that for MCA, mathematics is also a part of it. And yet for MCA, mathematics is not relevant.
That opinion was taken on the basis of the opinion given by the admission committee in that case. The admission committee says that, my lord, Mathematics is not the relevant subject for the MCA. That is why Supreme Court laid down that, yes, mathematics for MCA is not relevant. Paragraph 21 of that judgment. Paragraph in 2014 PSCC, page 767, paragraph 21. If Lordship peruse the paragraph 21.
In the presence case, Board of Appointment has not stated that postgraduate degree in mathematics is the relevant subject for MCA.
Yes, ma'am.
You are relying on that.
Not mine. Yes, madam. The mathematics is not the relevant subject, madam. As per that,
Has not stated
has not stated. Yes,
that the postgraduate degree
Therefore,
in
my lord,
mathematics
the-
is the relevant. Here, the expert committee has not stated that.
mathematics was not relevant.
Here also, the university has not said that it is a relevant subject. That is the whole
Allied
problem.
subject.
Allied
I
subject.
on point number 2, my lord.
The
Eligibility-
point number 2 is not here.
Yeah, my lord. Page
That is,
59, my lord.
that is what we are asking you. This point number 2. That reasoning is under challenge in this writ petition when the selection committee made that reasoning.
Yes.
We will take a call on that. Once we say that the selection committee is wrong, are we required to decide even the Dibrugarh University's reasoning?
Since, my lord, they filed their affidavit on the basis of this information, my lord.
They filed it as a, that it is an allied subject.
Yes, my lord.
They have gone against. They have said it is an allied subject.
Allied subject.
Okay. Yes, sir. You are appearing with him. Give him some. Mr. Upamanyu, allow them to be together. He may be able to find it. Yes. Otherwise, you are disposing of that. Dibrugarh University matter why?
Lordship, in that case, Lordship, there's a particular government in this petition.
Hmm? It was also on the relevancy of this subject, geography. Geography.
Lordship, please to come to paragraph 8, your lord. Page number 9, your lord. Paragraph 8, page number 9, your lord.
Paragraph
8, page number 9.
8, page number. Paragraph 8 of what?
Of the petition, writ petition, your lord.
Paragraph 8, page number 9 of let's try.
The petitioner had written to the Director of Higher Education, Dispur, Gauhati by letter dated 17/5/2024, requesting for re-evaluation of the interview procedure of the post of Assistant Professor Geography, SC category, Tinsukia College, on the count of the selected candidate.
There was a representation.
But it also says that petitioner was asked to attend for a hearing on 10/6/2024 with relevant documents. By the said communication dated 7/6/2024, the petitioner was asked to attend for a hearing on 10/6/2024 with relevant documents. The petitioner accordingly attended the hearing on 10/6/2024. However, no decision reached at the said hearing so held on 10/6/2024 has been communicated to the petitioner. To the government, so in that case, you can go back to the director also.
Nothing.
Then hearing can complete. Then hearing can be completed.
They filed the affidavit.
The hearing can be completed.
Department filed the affidavit.
The hearing is still did not come.
Okay, October.
You can go back.
The hearing done, my
Let the hearing be done.
That would take its time. It is before to this court, my lord. The affidavit of the department is on record. Department is allied subject.
No, this is an
Responsible.
opinion, Lordship, this is an
This is
opinion.
affidavit on record.
This is an opinion asked for by the higher secondary. Let the hearing take place. Let them go for the
This is
hearing.
an affidavit on record by department. An officer has, responsible officer has sworn the affidavit. There is no question of a hearing. 24.
Okay. Judgment, hearing concluded, judgment reserved, list on. Day after tomorrow, for delivery of orders, we'll dictate it in court. Day after tomorrow, we'll dictate it in court.
Will any submissions be allowed on that then, Lordship? Or?
No more submissions, we'll simply start harding so and so and so and so.
But Lordship, this is a relevant aspect, Lord. They
Huh?
said that the hearing,
We'll record it.
yes, hearing was to take place.
We'll record.
The hearing took place, the question.
We will record that in our order.
And second point, Lordship, if I may permit to put one more point, Lordship. In the entire petition, Lordship, they have said that these are two distinct things. The masters in MSc in geoinformatics is not a part of geography, Lordship, but not a single annexure indicating how exactly is it different.
We know by the day. We say that we say.
But Lordship, in a writ petition, in a court of writ Lordship, probably we cannot grow wiser by the day. That
And-
Mohinder's, that MS Gill comes into play.
No, Mohinder.
No, not from the petitioner side, Lordship, but
Mohinder is
definitely,
something different.
definitely.
Okay, different.
comes in. Lord,
Day after tomorrow we'll dictate.
Lord,
That Dibrugarh University judgment, if anyone of you can get hold of, it was disposed of. It went up in appeal and was dismissed. I forget the name. Perhaps the subject is geography. Geography, some, what do you call it? Petro geography or something like that. Some very twisted subject. Two of them had claimed that they were there. One was found to be not there. There, this history and everything was taken into account. Whether being part of a subject will be the subject. It will help us. Hmm. Yes. Yes, sir.
I had filed your petition affidavit
Hmm.
on 22nd of April.
Oh,
Lord, I just want to say
Hmm.
whether it's a relevant application or not. There is a transfer matter. Lord, Your Lordship, I can pass it on to Your Lordship, kindly see whether it can be entertained anyway. Lord, in the last occasion, it came before our Justice Chaitya. Well, His Lordship has said, I'm rejecting it. You file it is a fresh cause of action, you file an independent petition. Independent petition does not mean you file an affidavit. And what is that, Your Lordship? Just reporting officer is supposed to be changed. Now, how it interferes with the transfer order? Transfer order is a petition, well, transfer had been challenged.
Hmm.
And on the ground, Your Lordship, kindly see, if I can take Your Lordship to that. Your Lordship, kindly come to
The
page.
original writ petition is challenging a transfer order. And during the pendency of the writ petition, they have changed your
They have changed the norms.
APR channel.
That is one of the norms. The second, that they have also given an office order which has been during the pendency of service, in which they have changed the terms of service. So the basic fact on which is asking, not.
What is the term of service which is
That was
changed?
that was initiated for 4 years.
Hmm?
And that was for 4 years
Hmm.
up till 26. April 26.
Hmm.
But now they have made it up to April 27. So the ground on which they have carried out the transfer, that there is a requirement for these who are living, but who that ground no longer stays. We are already in May. And they are saying that it is expiring in 26. We are already in May and they are still serving. So the ground itself is nothing. Well, that is what we have brought up in this.
No, I will require a bit more. We require a bit more understanding on this. I'm not being able to get. There was a transfer order. The transfer order, pendency of the writ petition, they have changed some
They changed the norm.
norms. What was the norm which was originally there?
It was for 4 years.
4 years of what?
Starting from, it was the contractual, so 2022. Just 4 years becomes April 2026.
Your term of service.
No, my lord, it's not his terms, he's talking about others. How it is related, I don't know.
Lordship, it is related. It is related because my transfer was on the exigency that these persons are needed. So, and whereas.
Let him place the matter from the beginning, otherwise, my lord,
No,
you'll
it
not get
is
anything.
difficult, but today. It is anything. I don't know whether it be possible today.
My lord, can I suggest one thing? My lord, this matter may take some time because your lordship, the transfer order has been stayed. There is nothing in the transfer order, they themselves, what they have said, I'm just taking a notice. My lord, the order was, the transfer order, your
She
lordship,
has been transferred from here to Dehradun.
from Rishikesh. At
Rishikesh.
page 26, your lordship. After that, my lord,
If it is under stay, can it be under stay for some more time?
my
Say
lord,
for a week
enough
or
time,
two,
by 5 months is gone.
for a
In
week
the
or two,
5 months,
for a week
they
or
are
two,
enjoying.
for a week or two, sir, we
No,
tried to
only
make up.
your lordship can fix on 27.
Lordship, in this.
My lord, it was,
affidavit, I have
the
given
undertaking was
19
there, the entire
19
matter,
causes in which I have been.
On 27th.
27,
27th is day after tomorrow.
yes.
Tomorrow and except day tomorrow and day after.
Tuesday next.
Just a minute. No, 2 weeks. You are enjoying, my lord. They are enjoying that. Harassed means what is, just one thing, my lord, your lordship kindly come to page.
Both councils know
Well,
once
para
we,
20.
both councils know once we are saying that
No,
give us
your
a date,
lordship,
we
kindly
will
see,
not be deciding the matter today, so why is it?
no, kindly see para 20, page 13 of
Give
the
us a
writ
date.
petition.
Either two,
Enough is enough, my lord. Just say,
either Tuesday or,
no, my lord,
just give us a date. We will not do it today.
my lord, on 4th,
At the
already order is there, my lord, the
due
endeavor
to
will be
paucity of
taken up.
time today at the consent of the parties appearing for the matter, this matter again in the court of June.
Yes. My lord, the,
Parties would be at liberty to make a mention of the matter in the morning. The interim order continues till then.
and already, my lord, your lordship has passed an order, the endeavor will be taken up to sort out the entire matter.
And therefore,
Already the order is there.
therefore, the paucity of time is what I had to add.
Yes, I understand, my lord. That's the
We'll,
reason.
on the 4th of June, we have given you the liberty to make a mention of the matter
Yes,
in the
right.
morning.
Much of it.
Happy.
Much of it.
Yes. Is that it?
And
I'm the legally married first wife of the only come to.
No, they are not paying you the pension. No, why? Why? Any reason given?
Actually, what happened in the pension book, second wife name is there. But the thing is that there are judgments are there, my lord. Second wife cannot claim anything, pension, anything.
So that she is the second wife and you are the first wife. From where do we understand that?
Only come to Supreme Court also given us by DNA test, as well as I have already claimed my pension from the lower court, from the family court. Only come to page.
Then what happened?
Then after that, I applied for that.
So you have got, yes, when he has got a court order saying that he is the first wife,
They have appeared also, Union of India.
Lordship on,
then how can you deny him?
lordship on that case, lordship, we need to take instruction, lordship.
On what?
Lordship.
You have filed your
that-
affidavit in opposition. Have you filed your affidavit in
No,
opposition, madam? No. AG, what are you saying?
Lordship, while sending the pension.
Why the Union of India? You are for the Union of India. Why is Union of India a party?
No, railway, I think. Railway.
Lordship.
20 battalion, AP battalion.
Only come to.
Your husband worked where?
Railway.
Then why is 20 AP battalion?
No, it is 15, I think.
As of now.
No, no, 50. I think 15, I think.
10 years of pension, huh? 10 items of pension. This is item 49. None appears for the petitioner on call list again on. Are you appearing? 49. Huh?
My lord.
At the request of the learned counsel for the petitioner, list this matter again on June 30th, 17th of June. Yes, sir.
This is the electricity selection and appointment to the post of Hong Kong party. As part their advertisement, I to pass 8 centers from Seba. But I have passed last 10 examinations from cities. And therefore they have that as non-recognized
CBSE is not recognized.
There is a, affidavit is filed, but I have some reservation because the guideline we have annexed, guideline says that it should be recognized by Assam, the state of Assam. Therefore, a stand was taken, but I have reservation to that. Lordship may clarify that.
You have filed your affidavit. I don't find a copy of the affidavit.
It is filed. It is filed on
The repetition, there is a direct.
in the Lordship may kindly take up 53, item 53.
Who has signed the affidavit?
Sujit Baglari,
Sujit Baglari.
additional director.
Hopefully from the SEBA.
No,
No. Hopefully he has passed from the SEBA and not the CBSE class 9, 10.
Actually, this Anganwadi worker and helper, this is guided by a guideline. That guideline says that the HS qualifications should be from the Assam Higher Secondary Education Council, or it is equivalent recognized by the Board Council of the Government of Assam. That is the stand taken, but I have clarified that that this is not may not be proper. Lordship may clarify. Yes.
Allow my. There is a state.
Para 4.
Now the selection process has taken place. She has
Lordship-
participated.
No. Her candidature was rejected
Then?
because she doesn't come under that
No, it
guideline.
is further ordered selection process shall be proceeded by allowing her to participate. Did you
Well,
proceed?
No, in fact, a mistake has been done, a wrong has been committed by them. In fact, what they have done, because before they received the order, Lordship has passed on 10th of January. On 8th of January, there was a selection and subsequently an appointment was made, but now it is cancelled. It was not brought to the notice of the authority.
So now, no, it could not have been because prior to that date, the selection was done. Order is of 10-1. Selection is of 8-1.
8-1, but subsequently it came to the notice of the
Then what happened?
Then now the selection has been cancelled and the first page is the order. Lordship's order, it is directed to cancel the engagement of friends. It was wrongly, the director is approved and the someone was appointed. Now the director, after coming to having knowledge of this honorable court order, that has been cancelled. And second page, Lordship will see the show cause has been issued to the assistant who has placed the matter for approval before the director because the honorable court order was not put to his notice. And third page, Lordship will see that
When was the approval given?
for appointment, director's approval is necessary. They completed the selection, sent it for the director's approval. Director has given the approval. Honorable court's order was not put to his notice. And subsequently it was cancelled, and the 11-3 order is there, it is cancelled.
So now what is to be done? That appointment is cancelled. So now we will say that you would allow her to participate in the selection process,
And accordingly,
or you are holding a fresh selection process.
Ultimately, whoever has applied among the candidates, that selection process has to be initiated.
Redone. You have filed your affidavit in opposition.
In the writ petition we have filed.
The contempt is for that.
During interim order. Order was.
We will accept their apologies for that contempt case, saying that it was done without being put to knowledge of the orders of this court, and therefore we do not find any contempt. And we'll close this. And for the writ petition, we will pass an order saying that if the class 10 from the SEBA is to be recognized, so is the class 10 from CBSE is to be recognized, and therefore her candidature will be upheld. Her candidature will be there, and she will be considered along with all the other eligible candidates to participate.
And the process will be
process should be brought to its logical and following the due process of law. Within a as expeditious as possible, huh?
That condition only for HSS can.
We will say that you being class 10 from CBSE are also eligible.
Yes.
Why should you open the competition for everybody?
Yes.
Disposed of.
Lot.
Dispose of the matter order. Writ and contempt. Contempt disposed of by accepting the apology and the cause swap. Writ petition on merits. Yes, item 59. That we will do in the contempt case.
Kindly come to page 22.
Ah,
Supreme Court order. Take paragraph 3.
page number?
22. Annexure 3.
Okay, what does it say?
Paragraph 3. Next page also. Now, after that, Gauhati Court. Kindly come to now page.
What is it listed for today? Orders and admission.
Orders, my lordship.
Respondent number 4. Anybody appears? Huh? List again on 15th of June. So we'll have it earlier. 8th of June. Awaiting service report on the respondent number 4. Please respond. EPS got an order from the Supreme Court.
As well as from the Gauhati Court, I have already claimed my fee. And they have appeared, India has appeared as a proforma case, and that number 2 wife has not appeared in that case.
And you're paying to her.
Right.
And her silence she is getting paid and you are assisting her to get paid.
Sometime may be granted so that we can bring the instruction after that. Lordship.
Now you are getting time till 8. After 8, after the respondent number 4 is served, we do not know how much time. You'll have to stop that pension the moment you do. Notice is served. Yeah. 8th of June, awaiting service report. Yes, sir. It is for orders. All parties are served. Huh?
Actually, I suppose get instruction regarding the.
May I please,
22-4. Yeah, no.
no, Lordship here, can, yes. Lordship
Yes, their
here,
names find a place. Then what happens? Yes, Mr. Gogoi. Are you
My lord,
audible?
yes, my lord,
Yes.
similar cases are coming up on 15th of June, my lord.
15th of June.
June, yes, in
Same
contempt cases,
contempt cases.
a similar type, my all my lord regarding payment of my lord, minimum pay scale.
Okay, we'll have it
Some
listed on
division is,
15th of June for
yes, 15th
everybody's
of June, my lord.
convenience. List these matters again on 15th of June, along with similar matters which are, now since a submission has been made that similar matters are listed on the said date. One of them being contempt case number. Give us a
My lord,
contempt case number.
I will,
Please
I
provide
will
it to
provide
the
the
court master.
court master. I will provide it to the court master. Supplies, my lord.
329 of 2024.
70.
Contempt case number 329. Yes.
Wait, please.
Neither file any appeal or refute or co-appeal.
Yes.
Lordship, here in this matter, I'm appearing in item 70, supply 70, my lord. Here, my lord, I'm praying for some accommodation, my lord.
Why?
Because, my lord, we'll be bringing in the, my lord, the compliance report, my lord. So therefore, my lord, some time is required, my lord. On the last occasion also, I had prayed, my lord. Some time may be given to us, my lord. It's little this thing, my lord. At
This
least
is
10 days, my lord.
hampering compliance of an order of this court.
No, my
We
lord.
refuse
We'll
to
be,
take that as a ground. Sorry, Mr.
my lord, some personal difficulty today, my lord. Some accommodation, my
tomorrow?
lord. My lord, can it be taken up after a week, my lord? Because some time is required, my lord. I'm therefore praying, my lord.
Tuesday next.
My lord,
1 week.
on a Friday,
Tuesday
Friday.
next.
Friday, my lord. Friday.
Next Friday.
Friday, my lord. I'll try to bring
It's
because
not
I'll
next
be
Friday.
same, my lord.
Today? 29, huh? No, next Friday, 5th. List on the 5th of June. By which date the respondent shall ensure compliance of the orders of the court, failing which their personal appearance may be.
Now the personal appearance part may be taken out,
No,
my
no,
lord, but
unless you comply. If
my
you
lord,
comply,
my
we
lord,
will not call you.
my lord. Obliged.
Lordship, 71 is a review application.
Yes,
In
madam.
fact, it came last
Yes, we
week and
remember some.
missed it, madam. Page 27.
But we gave some order for costs.
Yes, madam. That may
How much?
be lordship,
Where is that order?
lordship. Lordship is 14 onwards.
Page?
Lordship
14.
is 14. The counter affidavit should invariably filed by 25 to 2026 with advance copies. In case the counter affidavit is not brought on record, so and so, the respondent shall be liable to pay a cost of so and so. That may be recalled, madam.
Gauhati had to fire it. Welfare.
Not sure of BTC when finance comes out, the government of Assam, my lord.
Hard needs. BPL, senior counsel, assisted by and a counsel appearing for the applicants in legal petition number 84 of 2026. Step by this order. By this application, the petitioners pray that the condition imposed upon them to pay a cost of rupees 15,000 in the event the counter affidavit is not brought on record by 25 to 2026 in WTC number 4868 of 2022 and 3106 of 2024. The learned counsel submitted, the learned senior counsel submitted that
Office subsequent order passed by another court and bench.
that is what I was trying to
No,
say. Is the order
yes, page 17 on.
amply complied with something like that?
Yes, madam.
That-
Page 18.
That
Mr. BK does learned counsel.
the affidavit had already been presented for filing on 25 to 2026, but could not be brought on record. Else there was some registerial, some process in the registry followed footstep. Accordingly, this court is of the opinion that the been taken by the applicants to have the affidavit brought on record. That steps had been taken by the applicants to bring the affidavit on record on or before 25 to 2026, and therefore the condition of imposing a cost of rupees 15,000 on the applicants is required to be recalled. Accordingly, the same is recalled. The petition was supposed to be. No,
The two
Mr. So-and-so appears for the repetition or opposite party. You have no objection. You have got the affidavit. Huh? Now the writ petition. Any orders to be passed on the writ petition today?
Lordship, actually on similar ground, coordinate basis is the space of case, writ appeal is pending.
This matter, this is repetition again after 2 weeks on a date to be fixed by the registry. 2 weeks, huh? Which has been disposed of by a coordinate bench.
No, he is neither, may not have claim for salary. I may be.
Waiting for the question. They have filed their affidavit. I am waiting for withdrawal of my
Withdrawal of
application
order
In case of
termination.
audit, they have already, their all for the already
their service was regular and it is following the standard.
No,
They are saying that they will
consider your course. They will consider your case.
For financial section.
Stage will come for payment, my lord.
They are making the apartment.
So what is the order you want today? We said list after 2 weeks. You want anything to be added to it?
Let it come, lordship, after 2 weeks then.
Private.
2023
On the 5th
matter.
of June. 5th of June.
5th of June,
5th of June. If there is any progress, Ms. Bihar, let us know.
my lord.
Any progress in the matter?
Otherwise, they are saying that they have been considered for regulation.
On 5th of June, if there's some progress, good enough. Otherwise, we'll close it, giving them the liberty to do it within the time frame that they can.
He's sleeping over his rights, my lord. Backbencher and prevailing to, my lord.
Past the arguing hours. Now it is
Bless
just
you, Lord.
finishing hours. Yes.
Only because of the
Obliged.
error of your law. Then finally they
Okay, let me
come.
back to
See, that's not this way. You
Okay, let me back.
On 5th of
5th of June, December. Yes.
DCR, that was for a left of the other. Here for wait for. But amendments are shown here in this.
Yes, any objection to this? They want to amend the prayer.
I'm for easy, man. It's not him.
None appears for the respondents on call except for Mr. S.K. Medi. Oh, yes, Mr. Bhattacharya.
Yes, my lord, that can be allowed.
Because of this VC thing, so we are dragging it into a little bit late.
My lord, no difficulty, my lord.
This
Absolutely.
prayer for a amendment to the synopsis and cost title. And
Yes,
also to file an amended writ.
Yes, my
She
lord.
wants to include
Because
some prayer,
substantially,
apparently.
yes,
Some prayers
substantially,
are, some prayer is to be included.
yes.
Heard. Mr. So-and-so
In fact, my lord,
consulting for the petition.
petitioner has, in fact, my lord, the writ petitioner has already been granted with all the retirement benefits, 7 except my lord DCRG. There's a technical problem with the Accountant General Office. The GPO has not been issued. Now that is an admitted position on the face of the record, page 18 of the writ petition, my lord. This is how, my lord, the matter, my lord, is on a narrow campus.
If we allow this writ petition, the DCRG part will come in the writ petition and we can either allow or reject the writ petition.
No difficulty, no difficulty, my lord. Let the writ petition I amend, my lord. No
But Mr.
difficulty.
So-and-so Learned Counsel appearing for the petition, also heard Mr. Arbor Pujai, Learned Counsel appearing for
But here, respondent number 6, my lord.
respondent number 6, 7.
What?
Mr. Medhi appears for the respondent number 3.
Three in the IN.
Irrigation, any specific standing counsel?
Irrigation.
And pension? None appears for the respondent number 1, 2, 3, 1, 2, 4, and 5.
5 minutes.
No one is appearing today.
Five.
Full stop. The petitioner the applicant in this IA has made prayers for allowing her to amend the writ petition in the following manner. Okay. You will give from para 2, 3, 4, 5, 6, 7. Full stop. The Learned Counsel for the applicant has prayed that the prayer for making the amendments be allowed, and the petitioner may be allowed to file an amended writ petition. The Learned Counsel for the applicant has been heard. The Learned Counsel for the respondent is object to the filing of an amended petition, since the amendments would in fact help in the adjudication of the matter. Accordingly, the amendments proposed by the applicant are allowed. The applicant shall file an are allowed. Full stop. Applicants would be, would file a amended petition. WPC number 4424 of 2023. Full stop. Accordingly, I is allowed. Full stop. I have to go. Read petition done. But today by an order dated, today by an order passed in I number so and so. The amendments proposed therein have been allowed. Full stop. Accordingly, the petitioner shall file an amended writ petition in the matter by serving extra copies on the standing councils representing all the respondents. Full stop. List this matter again after 2 weeks of the amendments of the amended writ petition being filed. Full stop. In the meantime, the respondents would be at liberty to file their response to the petition if any. Stop.
My lord,
Thank you.
I'm so obliged.
Yes, very good. Have you received it? Has the AG received it? Yes. Although the matter was called up at an earlier, during the earlier round format. Due to positive time, the matter could not be called up within the court working hours. Accordingly, list this matter again on Tuesday next. Tuesday next. Mr. J. Leonard, Senior Counsel, appears with the assistant of A. Sharma for Accountant General.
No, Madam.
For-
Go back.
Madam, on accountant. We'll have it on Tuesday, sir.
Madam, yes, Madam, I am appearing for. One,
Sharma,
two,
कर सकते हो AG अपन में.
three.
E. Huh? Yes, sir.
1 to 4.
1 to 4. We'll have it on Tuesday next.
I am appearing today, I think, Madam.
The file refuses to come to me. It is getting tagged there. Yes. Huh.
As far as I am being the punishment of compulsory return and other punishment because where it's repeatedly without no presenting of appointed director. Process as well as because 8 independent evidence were taken into I can reply, but not even single principal method for what evidence they said and what my reply has said. What is the method of allegation that one video brief transmitted from a mobile to that informants mobile, whereas at the same time other one mobile also that received that video. That one video while I was starting my personal video with the center. This is only allegation without and if they have protected without and in the inquiry report, sorry, in the finding law, the impugn order, it is against considering the activity, the seriousness of the matter in this way, the child harassment at the work, where is the workplace? The starting from that video transmitted to that from the mobile, it is the offense committed, it is working place, all the witnesses of the office may not even single evidence against me, Milord. Even informal highlighted that video, she shared my video to other cases, Milord. That is my personal video, Milord. So, Milord, under this, I am being.
So this is a war of videos.
Yes, Milord. And company retirement imposed against me, Milord. People put that in time.
We'll have to try it on some other day.
All the occasion, Milord.
Sir, you have the records with you?
Yes, sir, I have.
Records are there. When is it convenient? When is it convenient?
Kindly.
We'll have it on
2nd of June, Milord. Kindly.
no, 2nd of
4th
June.
of June, then 4th of June. Kindly.
4th of June, sir. 4th of June.
Yes. Kindly, on top of that.
At the consent of the learned counsel for the parties, list this matter again on the 4th of June. Parties will be at liberty to make a mention at the mention hours. Remind us if we do not have a long distance. Thank you.